Yeah. Item number 1. Yes, sir.
Yeah.
Why review?
My humble submission, earlier already the petitioner has paid 6 to 7 lakhs to the opposite party.
Yeah.
And there is also there is judicial separation. There is no divorce. The matter was filed in respect of divorce and challenging the order of the learned court below, that is the family court Khorda.
Yeah.
That is judicial separation. Now the petitioner wants for permanent divorce from the opposite party, and also the financial, though it is 25 lakhs. So she wants some changes in the amount.
Yes, sir. Any legal proposition, sir? What you are saying that that's a kind of a, if I, with your permission, if I say it's a drawing room discussion. Sir, in a court of law,
Yeah.
with judges, we have to entertain legal propositions.
Legal.
Sir, make the best legal proposition what you want to make. Not this, sir, he paid 30 lakhs of rupees.
No.
Already he has paid rupees.
I oblige.
You are not listening, that's the problem. It will not register to you. Which is the best judgment and scope of judicial review, review under CPC? Any judgment? Actually, what you are saying, there is not a legal submission. It's more kind of a emotional outreach to the court. I have paid 1 crore of rupees, now judicial separation already. So you must make some legal. Usually, you can also rely on so many decisions of the Supreme Court, everything, where these kind of arguments have been entertained. That makes it easy for you and definitely much easier for us also.
Maybe settlement. Can there be review in settlement? Generally, the review is not.
Though it is a settlement, but there is the order of the learned court below for judicial separation.
Correct.
But there is no divorce. Divorce and judicial separation is completely different.
That's true.
The petitioner wants for divorce.
That be a ground for interference. What is the ground on which? Where is the error apparent on the face of the record? Which is your ground for review?
Only the amount has been reflected in the order. There is no other things has been taken up by the judicial notice.
Yeah, but that is how you agreement with the arrangement which you have concluded after having discussion with each other, after having counseling from your advocates and our talk, together have brought about a settlement. Supplement.
Are you the counsel who argued this, or you are a different counsel?
I am a different counsel.
So don't make that mistake. There are 2 direct High Court decisions on this. Supreme Court decision also, because my lord, I mean, having phenomenal memory, I remember a Delhi High Court decision. So also, if your colleague has argued the matter, and these kind of arguments, usually it's an afterthought. You as officer of the court must guide your client properly.
Yes, he told me that he has already paid.
That why 25 lakhs? So you consult your client. At least if the other earlier counsel has been changed, you can consult him also.
No, also annexure running page 19, they have already paid as per order of the Hon'Ble court 4 lakhs to the opposite party.
Sir, for that, it is not that the judges have so lack of understanding that you have to tell that 5-6 times. And we don't expect any lawyer not to understand also. You have to take our conversation with you seriously. We are taking that. The fact that he has paid 4 lakhs or 13 lakhs, whatever you are saying, earlier paid so much of money. He has married for the second time?
No.
Not married for the second time. Then his requirements are much less.
Daughter and other family member.
Sorry, sir?
She has a daughter and a person.
Any divorce with the daughter?
No.
On the Hindu Marriage Act or?
No.
There is no provision, sir.
No, no.
No problem. The husband has moved this petition seeking review or recall of our order dated 14/7/2025 that has been founded on the settlement between the parties. First, the settlement is reflected in the memo which we have referred to in para 3 of the judgment. First, the Romans said, "Pacta sunt servanda," meaning thereby, what you have agreed to, abide by it. First, no exception is demonstrated to deviate from this age-old maxim. First, except contending that the husband has already paid certain sum of money prior to settlement, and that there is no dissolution of marriage between the parties, nothing is argued to undertake a deeper examination of the review petition, which obviously has limited parameters in terms of Order 47, Rule 1 of CPC 1908, or even otherwise. There being no error apparent on the face of the record. First half. Next paragraph. In the above circumstances, review petition being devoid of merits is liable to be and accordingly rejected in limine. First half. Registry to send a copy of this order to the wife by speed post for her reference. Okay.
Item number 2. Item number 2, my others batch matter is there. There are so many, the 10 batch matter is there. I have given a...
We decide this matter. In terms of that, batch matters also can be decided.
Yes, so paper only next week any date matter, so I will argue them, I guess. I have
That is two cases are there, two, and common judgment, but two cases having a slightly different fact, but judgment is common. Another case which the number is given. You have actually conducted two cases.
But bench is constituted only for this matter.
That is exact judgment, same judgment.
No, maybe.
So I have no objection. I have ready otherwise.
Yes, government. Who
it is central government and the railway and the railway.
This is a special assignment, special bench. We cannot draw some other matters here without the orders of Honorable the Chief Justice.
But I play next week any date, Lordship. I will argue the case. Next week any date.
So, generally before special bench.
Yes, any date I will argue.
Next week,
Next any date, Lordship.
It will not happen. There are week after next.
Any date, Lordship.
I mean, the registry has to fix it. With Lordship's kind permission, but not 2 days.
No.
I am.
Because brother is also in another bench.
I am having exacted to close the case. I am ready otherwise also.
We have
Now only what happened, it's not a case of the number is of very new number, bit of it. Really the litigation is of very old, 1992. These are appointment to land users. Therefore, will not Supreme Court has given 15 years relaxation, age relaxation.
For the petitioner, call this matter when this bench next sits. Okay.
You are CGC.
I am the senior panel counsel.
Senior panel counsel. For the petitioner. Mr. A.K. Bose, Senior Advocate, along with Mr.
Arpit Sikdar.
Arpit Sikdar. So, A. Sikdar.
Yes. Item 3.
Only
We can't fix date because when we are sitting, we do not.
I have only object for my trials and that.
No issue. No issue.
Release the case as soon as possible. That's all.
No, we 25 matters, so maybe that we should solve.
Only what happened, the litigation is old.
Correct. 99.
Under section 378, 1 and 3 of the CPC, CRPC, and
Pendency is under
30498A, 302, 201 IPC. And my lords, the findings of the learned sessions judge is that the death is homicidal in nature. It is purely based on circumstantial evidences, which and last in theory, my lords, which has not been properly dealt with by the learned sessions judge, my lords.
Therefore, learned session judge's order.
My lords, page
Complete technical.
13.
Complete
My
technical.
lord, my lord. Page 13, internal page 7. The lordship can see the last 4 lines. It is difficult to accept the contention of the learned defense counsel that the deceased died a suicidal death by hanging herself, rather from the signs and symptoms noticed during the postmortem examination, and further in view of the discussion made above, it has to be held that the deceased died a homicidal death which may be due to strangulation.
Then again, weakest point, weakest argument you can make in a circumstance.
My lords,
Whether homicidal or suicidal, the court will not. If it is a suicidal death, then the court will not.
my lords, I supplement with the argument that, my lords,
Listen, sir.
my lords.
See, the standard of proof in case of a standard of argument should be the best point you should argue first. Not that the death is homicidal.
Yes.
If death is suicidal, there is a discrepancy that would make argument for the defense. If the defense, the accused makes an appeal saying that it is a suicidal, that is not, the homicidal death has not been proved beyond reasonable doubt. So that argument, why you are arguing?
My lords, it is purely circumstantial in nature, my lord.
So you argue the best point. In favor, or you prepare as the other matter has been adjourned also. Yes, Mr. Das. What is the best evidence as an officer of the court against
my lord? No, against me. Actually, the trial court has found it to be a homicidal death, as per the doctor's report and
Not a suicidal case.
Not a suicide case, as it has been held. But the other evidences has been decided in favor of the accused. He has analyzed all the evidences, and if your lordship permits me, it is at page 19, from para 29 till the end. He has analyzed all the evidences and has come to a finding that it is not proved that the accused is the author of the crime. That is the finding of the trial.
Can we elaborate? So your response is that nothing has been missed by the trial court as far as evidence on record is concerned.
Yes.
So is it that the chain of circumstances has been broken?
Broken, according to the trial court.
Broken.
Yes.
Leading to the last scene and chain of circumstances.
Yes.
Okay. So now, Mr. Beura, then you have to show us that there is a continuous circumstance chain of events leading to the proving of guilt. But may not be today because the way you are arguing, I think
One.
No, not granted. No, not granted. It has to be granted.
They can't be for the because of the also 80 and 81 also. But I thought that it's granted, so I asked him. If you want to argue on in terms of 81 Supreme Court, it cannot be granted or you will accept the grant of it.
That,
If you want to engage, and it's not as at paragraph 29 of the order of petition. Learned session judge has declared explicit D said the death was decided as contradistinguished from suicide. Learned counsel again for the service regardless of nature of death, there is no implicatory evidentiary material to link these clients to the commission of the crime. And this aspect having been deeply examined by the Vigilance, a mention of happening as well and cared for. No, it's not a case where it given to be children. Ordinarily, where in the case of homicidal death, as distinguished from suicidal, which aspect was related with the defense, or the matter needs a deeper examination. Since no homicidal death should go unbeaten, custom, therefore, matters merits deeper consideration at the beginning of the stage of it. And at this stage, we are very much facing the incident needs to be informed to facilitate such things are first, next person. There was purposes, the application and the word. Need is important. And the appeal is immediate. For a person. We should we must take book little paper registry. Registry to prepare a paper book within 8 weeks. It is open to the heads to collect a copy of the paper book so that the kind of the scan.
the my lord,
My lord,
the
after leave is granted, it will be renumbered as criminal affair. The my lord.
government.
If that's original.
My lord,
will be changed.
my lord, the accused is to be granted bail. Madam.
Application.
Well, this I think application is not necessary because he is already acquitted.
For the since his right have already secured an acquittal and of the Angel, he should be granted bail. Having heard learned advocates and the papers, we are considering that the accused may appear before the learned session judge who at the trial and seek bail at his hands.
But if you will not grant, then the acquitted person will go inside, go behind the bars. Supposing he rejects the bail, my lord,
Appeal is admitted.
my lord.
Then there is the question of if you continue to be accused only, and whether there is such a procedure in your criminal books of practice.
It will be in three,
State to state.
no, my lord,
What is the procedure?
according to 390, I suppose it is 3.
Requested to favor the application is made by the accused, subject to usual terms and conditions. Alright? I do not know what are even some criminal practice.
Into 390, I suppose.
I'm not going to ask it for you have to surrender to the we have told them to favor your application.
There is not because the festival is coming. You also celebrate festival and permit us to celebrate also.
Then Lordship, I pray.
We have it in the second week of September.
May I take your lordship?
Any date 9,
Should not much
8 or 9, let's 8 or 9.
Let us see. They will organize because many matters we have already posted.
But this is a matter of the PCPNDT Act, my lord. This petitioner's ultrasound unit has been closed down. His machine has been sealed for no good in April, my lord.
It's in April.
My lord. And despite the clear observation of this honorable court, my lord, because he's the only source of livelihood, my lord. And since the ultrasound machine, without any reason, without citing any provision of law which it tolerates Monday. Can I pray for Monday?
Not this, not coming.
Because my lord, since April, my lord, his machine is his suffering, my lord, his only source of income, my lord. Because
Since April, nothing has happened.
my
4
lord, for
months
the last
ago.
3 years, my lord, this is the third round of litigation, my lord. For the last 3 years, they are harassing him for no good reason, my lord. Oh, bless my lord.
My lord, petitioner is a poor teacher. The opposite party is as the illegal order in removing
Which year?
2024 minor.
24?
Minor.
It's in the second week of September.
I just pardon to mention, this is the case, my lords, where the BMC has undertaken certain construction for which the entries and egress of the petitioner has been stopped, my lords. Your lordship on the last occasion directed in case of any urgency, I shall mention for the interim protection, my lords, and they have started the construction, my lords. That is why I am mentioning it.
But ingress is left.
No. Now they have started the construction just beside the house of the petitioner, my lords. That is why I am mentioning this case.
In their property. In your property.
In their property, my lords,
Yeah.
but in the cremation ground only, my lords, that ground was used by the villages of that village, my lords, for egress and outrace, and that construction will block their.
Correct. You should have left space while constructing your building.
I have constructed my building in my plot, my lords.
Without leaving any space.
No, my lords, but ingress and outrace to the path or connectivity to outside, my lords.
Tuesday.
I want to mention, Your
Grateful,
Lordship,
my lords.
it is a 2024 matters.
Huh?
2024. The matter was listed on
Third week of September.
Yes, my lord, but the matter in this platform matter, your lordship, which is similar with the 208.
Covered by judgment.
Yes,
It's already.
yes.
Next week.
Pardon to make a mention, Your Lordship.
Monday night.
This is a matter with regard to recruitment of a young bright child, Your Lordship. He has already completed, only due to shortage of 1 and 2 marks, he has been failed, Your Lordship.
2 weeks.
We commencing month of September, Your
It's
Lordship.
for admission.
Yes, Lord, for admission.
After notice or before notice?
After notice, Your Lordship.
After notice. Yes, third week of September.
Another one matter, Your Lordship, this matter is with regard to taking over of the management of the school. That matter may be
When it happened?
in the year 2025, Your Lordship, already notice has been issued.
Third week of September.
Not second week, Lord. This is urgent, Your Lordship.
Already we have booking. That's the reason. Yes.
My lord, this is a 23 matter.
23
Yes, my lord.
after 2 weeks.
I want to mention, my lord, regulation service 2024 matter.
24 matter.
24.
3 weeks.
My lord, my case is regarding the recruitment of multitasking staff in the IIT Bhubaneswar. One post has been reserved, but he was not allowed to participate in the selection process. Subsequently, also he was not allowed, but similarly persons have been recruited. The case may be taken up. Readings have been completed.
Which year?
2023.
20.
23.
23.
Awesome. Since then, the post has been reserved.
My lord, is it termination matter? Termination matter, my lord. 2020 matter, my
We
lord.
cannot. They can come in the. Yes.
My lord, termination matter 2020 matter.
20.
20, my.
2 weeks.
My lord, it is a 2015 matter.
2015 matter.
Yes, madam.
All right, 2 weeks.
2022 matter, covered matter, because already 2 only left that covered by of this.
Yes.
My lord, this is a 24 matter.
24 matter. 2 weeks. Yeah.
My lord, pardon to make a mention from the list, my lords. From the list, my lords. Item number 45, my lords.
Item number 45.
Yes, ma'am. If I may pray, my lords, it may be taken up at 2 p.m. or before rising of this bench, my lords.
Let us
Urgency in the-
if it reaches, we take. How long we can take out of turn? What they will feel about me?
No, my lords. I'm just telling, my lords, before,
Let us-
before rising, my lords.
Let us. Yes.
Your Lordship, pardon to make a mention from the list. Your Lordship, item number 41 and 42. We pay for 2 weeks' time.
Have you informed the other side?
Yes, Your Lordship, we have informed the other side.
41, 42. After 3 weeks. After 3 weeks?
Pleasure.
Very good.
Item 1. Item 1.
We have gone for harmonious construction of guideline number 2, 7 and 8. And we have also taken into account. In the first round, you said she is an untrained candidate. In the second round, you say she is a trained candidate. How this oscillation? No explanation, nothing. Therefore, we have allowed And we have directed issuance of selection and appointment order. Again, one more copper need not be sent back. Okay. In the above circumstances, this petition succeeds. A writ of certiorari issues, quashing the impugned order. A writ of mandamus follows to OPs to select the petitioner for the post in question in any of the vacancies and report compliance to the Registrar General of this court after issuing the appointment order within an outer limit of 8 weeks. It is made clear that such appointment shall be with prospective effect, and the petitioner shall not be entitled to any benefit. It is possible she should be given. She is like Jhansi Lakshmi Rani, who has fought the litigations throughout. Therefore, that I have kept open. An option is given to you to accommodate her somewhere. Yeah.
Yeah. I do it.
Item 2, may I bless it?
Yes.
My Lordship, the last occasion the government has sought for instruction regarding the furnishing of 11 documents that has been supplied by the principal to the opposite parties. It has already been supplied on dated 25/1/2025. The proof is there, my Lordship. I am supplying the
Last order last order कौन है?
He has already retired now.
Yes, my Lordship. His grievance petition has been pending before the opposite parties, my Lordship, since 2023, my Lordship. That may be considered.
25/1/2023.
Yes, ma'am. That may be considered. I my limited prayer.
You consider that, brother?
Yes, ma'am.
The short grievance of the petitioner, we have since retired from service on attaining the age of superannuation, is as to non-consideration of his or her.
His.
No, Srimati, nothing. His representation dated 25/1/2023, a copy whereof avails at Annexure
7.
Annexure 7.
Annexure 7, wherein he has sought for Dr. Mamata Panda. It must be she.
Yes. No, Mamata Panda is the deputy director.
Deputy director.
The principal has written a letter to her, but the petitioner is he, Kailash Chandra Naik.
That's all. But where is your letter for regularization?
That is my only grievance petition that has been pending, my Lordship.
Which is that?
In Annexure 7, 6/1/2023, 10 paragraph, my Lordship.
Annexure?
Annexure 7, page 17.
No, that is letter written by a deputy director to the principal.
Yes, my Lordship.
It does not relate to your demand at all.
My grievance is Annexure 3.
Then date is different. 2011-2017, a copy whereof avails at Annexure 3, wherein she has sought for regularization of her service. First, learned counsel for the petitioner complains that though years have elapsed since the filing of the representation and his client has already retired, no decision is taken on the subject representation, and therefore interference of this court is eminently warranted. First, next paragraph. Learned AGA, appearing for the OPs in all fairness, assures the court that the subject consideration shall meet, the subject representation shall meet due consideration at the hands of
Director.
OP number 2.
OP number 2 within a period of 8 weeks if all contentions are kept open. First off, counsel for the petitioner is agreeable with this proposition. First off, in the above circumstances, petition is disposed of, keeping open all contentions. First off, it is open to the answering OP to solicit any information, etc. No cause.
Obliged Majesty.
Only your lordship one line, if pending, representation if pending, because there is no acknowledgement, nothing.
Then we will say, let him give a reminder, one more. Otherwise, you will say there is no representation at all.
Yes, yes, let it.
It is open to the petitioner to send one more representation so that the process shall not be delayed in searching the one earlier made. Somewhere. Within 2 weeks, you should make that representation. Within 2 weeks. Yes.
May I please, Lordship? In this case, Lordship, the present petitioner in 1983
What's your prayer?
Yes, Lordship.
Let me understand.
My land has been acquired by the government and handed over to the CDA, Lordship, for plotting purpose.
Of compensation.
Plus, either compensation or they have CDA may be allotted the same measuring plot in CDA.
Equivalent
area. That's because it is land against land. They have acquired the land and sell out the land in high trust to the general public.
When acquisition happened?
Lordship, it has notified 83, Lordship, under annexure 2 and 3, Lordship.
No compensation is paid.
Lordship, they have. I have not received, Lordship. I am in out of station, Lordship. I have not received till date, Lordship.
How many years you were out of station?
Lordship,
where did you go?
Lordship, thereafter I have made repetition.
That's all right. You answered the court's question.
Lordship.
When the acquisition took place.
Lordship.
Suppose the acquisition took place 100 years ago.
Lordship.
And now if you come and say, no, compensation is not paid, who will keep the records for having paid the compensation?
Thereafter, I have made representation to the land acquisition officer not to acquire my land, as because my land is meant for, I have purchased the land for purpose of my shelter, Lordship.
When did you purchase the property?
Lordship, 84, Lordship.
Sale deed.
Lordship, annexure 1, 83, Lordship.
Full date you have to give.
Lordship. 21st September 1983, Lordship.
1983.
Lordship.
Your sale deed.
Lordship.
In your name only?
Lordship, some of the people also purchased the land along with me, Lordship.
Annexure?
Annexure 1, Lordship.
Annexure 1?
Lordship.
When the acquisition was notified?
Lordship.
Under which act? The 1894 Act?
Lordship.
1894 Act. One is dated?
Lordship. Initially
notification is dated?
Initially notified, Lordship, 1983. Subsequently, as because it is not carried out, Lordship, they have subsequently notified in
84, annexure 3.
Lordship, annexure 3.
When the final notification was passed?
Lordship, 86, Lordship.
You have to give, there is no culture of giving the date at all.
Lordship, I have mentioned, Lordship. Annexure 6.
You give the date of preliminary notification first.
Preliminary
notification. Dated?
Lordship, 18th October 1984, Lordship.
That is 4-1. 1810?
18th, yes, Lordship. Thereafter, Lordship.
1810? Year?
Lordship, 84.
84.
Lordship. Section 6.
Section 6 was issued?
Lordship, that is issued in 84, Lordship, that is. 18 October 1984, they have issued Section 6 notice.
4-1 in July, 25th July 1983.
83, Lordship.
Annexure 2.
25 July 83.
Lordship.
When the award came to be passed?
Lordship, it is Lordship 31st May 2000.
When was
88 Lordship, 1988 Lordship, Annexure 4 Lordship.
date? You have taken Bhishma Pratigna to give, not to give dates at all.
Lordship, I have mentioned in date.
You mentioned that. You should give full date now. Award dated
31st May 1988 Lordship. 31st May 1988 Lordship.
88.
Under Annexure 4 Lordship.
Award was passed. Yes, sir, there is an award. You have taken the property, and he says that no compensation is paid.
Accordingly, I have made
representation you have made.
Yes, Lordship.
On the basis of, suppose if you have already taken money and if I pass order,
No,
representation.
I have never received any money, Lordship.
You have never received?
No, Lordship.
But generally, how you will remain so many years silent?
Lordship, some is out of station, Lordship.
Did he go to America, Africa?
No, Lordship. Accordingly, I have made representation for exemption, Lordship.
Where did he go out for so many years? This is 31,588.
Lordship.
How to trace the
Accordingly, no, Lordship. What happened, Lordship? As I have one single plot, Lordship, I have made representation to the land acquisition officer not to acquire my land.
When was it made?
Lordship.
That you should have made in 5A inquiry, not after passing of the awards.
Lordship.
5A inquiry, you should have
And,
said, this is the only site, sir, you don't take it, it will be difficult to me. Then they would have considered that.
Lordship.
Once the award is passed, what is that you are making application?
Lordship, in 1997, Lordship, I have made representation to the land, so exempt my land or allotted land against the set patch of plot, Lordship.
Where have you stated you have not been paid compensation?
In my representation, Lordship.
Yes, read.
Page 34, Lordship. Relevant person. Relevant person. Page number 34, Lordship.
34.
Lordship.
Where have you stated that you have not been paid any compensation? Read one sentence.
Lordship, I have came from the recent effect.
What?
Relevant para 3 and 4, Lordship.
3 and 4.
Under these circumstances,
Under what circumstances? Under these circumstances,
Lordship, above para as because
where have you stated I have not received the compensation? It cannot be. My common sense, coupled with judge's sense, lawyer's sense, says that you would not have stepped over the matter without money.
Lordship, I have not, as because I have not received, Lordship,
where have you stated?
My prayer, Lordship,
you may pray so many things, sir.
Lordship.
But all prayers will not be answered by the court. You show
Lordship,
that you have not received the compensation. Very thank you. In your petition, show it in the petition. Where have you stated?
No, Lordship, in the page 34, Lordship, with his representation, only request him to not acquire and give me a piece of plot of land in CD area, Lordship, against that acquired land, Lordship.
No, where have you stated that you have not received the compensation? Once, see, if a land is acquired,
Lordship,
you are entitled to compensation, nothing beyond that.
Lordship.
Unless the law says that some other law saying that you should be given compensatory plot, etc.
Lordship.
All along he has agitated before the authority that to provide a suitable plot of land instead of
No, where have you said?
That is Annexure 37, page 37, Annexure 8. A letter has been written by the Secretary, RDC,
Lordship,
to the page 37.
Saying what is that?
Saying that to consider
such a land acquisition, he may be allotted alternative land by CD. Where is your right to alter, right to claim land? V.G. Ramachandran on land acquisition says, accept the compensation the land loser has no other right. Ask V.G. librarian to bring that V.G. Ramachandran law of land acquisition and compensation. No case made out.
It's because of it is land against landlord.
No.
Lordship,
Petitioner,
Lordship, may I tell Lordship? My compensation amount may be released, Lordship.
where is the prayer?
Lordship,
Where is stated in your representation?
Lordship, last representation, Lordship, I have made, Lordship, in 2024, Lordship.
Now, unless you show that you
Lordship.
have not been paid, because this happened in 1988, when you were not liar, perhaps. You were not, because I was also not.
No, Lordship. My limited resources, I have my
This
friend.
acquisition took place, award is passed, but I have not been paid the compensation. That is not
Lordship,
your prayer.
My prayer,
Otherwise I will pass an order keeping V.G. Ramachandran in my mind.
Lordship. In my prayer, Lordship,
Page 42, on 8/4/2024, paragraph 4, he has prayed for to release the compensation amount subsequently.
In your petition, have you stated now compensation is paid?
that I have not stated, Lordship, but in my prayer part, Lordship, I have pray for release my compensation.
Lordship.
But if I pass an order,
Release
in the guise of that, if the compensation is given twice, they will say court has passed an order and therefore we have given. That some things have happened, which Apex Court took a note of in Abdul Hamid versus State of Karnataka.
May I pray, Lordship?
Yes.
May I pray, Lordship, for dispose of my representation, Lordship. If I have received, then they may be denied, Lordship.
The short grievance of the what you kind of no preparation, no book is cited, no decision is cited, no law is cited. What kind of arguments? They suffocate me. I don't feel that I go home with some value addition, except where one or two lawyers like Swain, etc. Nobody is making any value addition to me. I'm doing masonry, no architectural work at all. You are treating me as a mason. The short grievance of the petitioner is as to non-consideration of his representation dated 8/4/2024, wherein he has sought for payment of compensation in respect of the land acquired pursuant to preliminary notification dated 18/10/84, passed under section 4(1) of the 4(1), followed by 25/7/83, passed under section 4(1), followed by final notification dated 18/10/84, issued under section 6(1) and 6(1) of the Erstwhile Land Acquisition Act 1894. First of all, counsel says that the award has been passed on 31/5/1988, and till this day, neither compensation has been paid, nor compensatory site has been allotted to his client, and therefore this court should come to the aid of the petitioner. First, next paragraph. Learned AGA appearing for the OPs opposes the petition, contending that law will not come to the aid of sleepy and tardy, decades having lapsed after the alleged acquisition process having been accomplished. First of all, having so contended, now he submits that the subject representation would be considered by the concerned OPs within a period of 3 months, if all contentions are kept open. First of all, with this proposal, petitioner's counsel is agreeable. Next paragraph. In the above circumstances, this petition is disposed of, directing the authorities to ascertain very carefully whether any compensation has been paid in respect of the subject plot in question, subject plot, before examining the representation of the petition. First, all contentions are kept open. Nothing is expressed. No opinion is expressed on the merits of the matter. First up. Yes. No problem. Item 4. Next time when you come for land acquisition matter, you should come with V.G. Ramachandran's law of land acquisition and compensation.
Yes.
Okay?
Yes.
That does not mean till then you can sleep over. Till then you should spend time in the library.
Yes.
Yes. Otherwise, again substandard argument. Next case also. Yes.
Item 4 on behalf of my learned senior, Mr. Roy, I seek a pass over.
Pass over. No, pass over. How much time he spends? I have to say on law, I should convince the lawyer and then I should pass the order. Reverse, the lawyer should convince the judge actually. I have to convince them before passing the order. Yes.
My lord, I may be placed, my lord. I may be allowed to appear through VC, my lord.
Yes, sir.
Obliged, my lord. In this repetition, my lord, the present petitioner is has knocked the door of your lordships for praying for the arbitrary and illegal action of the opposite parties for withholding the area or outstanding bill of rupees 32 lakhs, my lord.
Where is that lawyer? He went away. All right. You go and bring that lawyer here and ask him to sit in front of me with that book. Yes. Yes.
My lord.
Yes, sir.
Am I audible, my lord? My lord. The present petition, right, before your lordships.
What is your prayer?
My lord, my prayer is, my lord, grievance of the petitioner shall not be allowed and further please to direct the opposite party number 2 and 4 to release the outstanding bills.
Sit with that book or court book. Sit for 2 hours till I rage. I read that. Take that book. Yes. I read. Wasting time of the book. Yes, release of bills.
Yes, my lord.
Release
This
of
is my
bills.
prayer.
Your representation.
My lord, earlier, my lord, I have approached this honorable court, my lord. Page Annexure 8, 133, my lord.
33.
My lord, vital portion is 135. This honorable court directed on the effort. May I read, my lord?
1 second. Direction for consideration.
Yes, my lord. My lord, look into the grievance of the petitioner under Annexure 6 series, also keeping in view.
All right. What happened?
Till that, my lord, the authority is sitting silent over the matter, and I have not got any single pie. The legitimate dues, my lord. I have been entitled to get, my lord. Moreover, my lord, the petitioner is suffering from gastritis and other ailments like liver.
That he has to, court will not give medicine. He has to go to hospital.
Yes, my lord. I have annexed, my lord, all the medical documents, my lord. My prayer is to release all the outstanding bills, my lord. I am entitled, my lord.
Hey, brother, take notice. There is a direction to release, and perhaps your officer wants something else.
I'll take notice.
You take notice and show the online hearing to your officer. Perhaps he wants something like buffers.
In the contempt petition,
Why there is a direction by the court?
yes, sir.
When there is a direction, why it is not complied with?
Page 139, your lordship may kindly see.
Yes.
The order dated 10/2/2025 in the contempt petition.
Correct.
That is the
First contempt.
since the yes.
First contempt, second, which contempt?
This is seems to be first contempt.
Seems to be first contempt.
Since the superintendent engineer and executive engineer, Rural Works Division, Baleswar has already taken a decision in the matter by considering the representation of the present petitioner, and the said representation has already been disposed of, hence no affidavit is required to be filed by the Law and Counsel for the state. So his representation has already been considered.
It is already considered.
No, my lord. Till date, my lord, no. My representation has already been considered.
Why can't you come to court so that we can have interaction? What I say, what you say, we are both are fighting with each other.
My lord.
You are from Delhi. Are you from Delhi?
No, my lord. I am, my lord, in home due to my ill health, my lord. I am from Baleswar, my lord.
Anyway, but contempt proceeding is dropped on the ground that representation is already considered and rejected.
My lord, kindly have the look into the grievance of the petition annexure 6, keeping in view the annexure 2 series. Till date, my lord, they have not considered my representation, my lord.
You are saying that twice I have said, learned advocate AGA says, on the ground that representation is considered, the contempt proceedings have been dropped. And that order you only have produced.
My lord, may I submit, my lord? Yes. On 9/5/24, my lord, the honorable coordinate bench of this honorable court directed to file affidavit. The compliance through affidavit, the compliance report filed by the opposite party, my lord. Till date, they have not filed any affidavit along with the compliance report, my lord.
They have said, the court said, there is no requirement of filing affidavit because already the representation is disposed of. Come to 10/2/2025 order.
Yes, my lord.
Yes, come to, you want the page 139.
139, yes, my lord.
Kindly see para 4.
My lord. In this order, my lord, they
only read it.
Yes, my lord. Honorable court, my lord, inadvertently have not taken into consider the prayer of the petitioner, my lord.
Short grievance.
Petitioner is suffering a lot, my lord, without getting in his legitimate dues, my lord.
Representation.
The right to liberty and livelihood is infringed.
For having accomplished the contract work in question. First off, learned counsel for the petitioner submits that once the representation is given, the OPs ought to have considered the same and informed the result thereof to his client. And this having not happened, this court should come to the aid of petitioner. First off, learned AGA resisting the petition draws attention of the court to the order dated 10/2/2025 entered by a coordinate bench of this court in contact number 8385 of 2023, wherein paragraph 4 reads as an next. In the above circumstances, the representation has met its fate, and if the petitioner is aggrieved by the result, it is open to him to pursue other legal remedies. In that connection, all contentions are kept open. Petition disposed of. Next. Item 6.
May I please, your lords. In this case, the petitioner challenged the premature release petition has been not recommended to the State Sentence Review Board, my lord. Annexure 1, page 22. His serial number is 23, my lord. At page 24. At page 24, 23 is his serial number, my lord. My only small prayer, my lord, as the board meeting will sit on month of September, his case may be recommended to the board. As he is already served 21 years of the life conviction, my lord, his case is fit to recommendation to the board, my lord. This
other day you appeared in another matter.
Yes. Is it legal matters, my lord?
I'm not very sure that this matter will come to me.
It is
that you are.
It is the.
We should allow the judge to speak. No patience.
Sorry, ma'am.
I also lose patience.
Sorry, ma'am.
No justice will be done to us.
Sorry, sir.
Judge is not supposed to lose patience, but the substandard being celebrated in the court hall,
Sorry.
it makes me lose my patience because I never come across such substandard bar at all. Yes. Now, there is some doubt. Residuary matters are with me issue. I have doubt whether this is a residuary matter.
My lord, this is a
Therefore-
residuary matter because the annexure 1 is a rejection order, my lord.
No, residuary means allotment of the sitting list.
In such matter, registry, your lordship may direct the registry to find out.
No, my lord, it is the.
I have made one wrong order now already.
No, my lord, already, and another matter was also decided by another judge in the WPC number 5520. Eight seତେବେଳେ assignment ସେଇଠି ଥିଲା ଏବେ ସାର୍ ଙ୍କ ପାଖରେ ଅଛି ଏଇ କୋର୍ଟ
Assignment ଜାଣିଛନ୍ତି?
When board is meeting? When board is meeting?
September, in the month.
September?
Yes.
Call this matter on 1st of September. 1st, no? 2nd of September. Let us. I'll just verify and count. Okay.
Registry may verify so far the assignment and residual assignment.
No, they are also not in a position to answer properly. I made inquiry because other day, the AGA told it may not come to, Mr. G told it may not come to my roster. But nobody is clear about this. Therefore, I'm just thinking we'll have it on Tuesday, 2nd September.
Item 7.
Petition is a retired lecture in political science. Petition is a retired lecture of the political science has filed the presidency application in action of opposite for sanction of a pension and pensionary benefit of the petitioner. The similar case already issued notice.
Notice is issued.
No, my lord. Here my notice is issued on 3rd week of September. That block grant persons, those are eligible to get the benefit of pension on that in division bench. It is posted. So 3rd week of September, all these matters
Issue emergent notice. Learned AG is requested to accept notice correspond any private party. First, call this matter in 3rd week of September.
Along with the WPC number.
Along with WP number
11539 by 2023.
539
by 2023.
2020. 25.
23.
Okay.
3 and 4 notice to be issued because
3 and 4 private parties.
that is governing
One
body
and
and
two
it is
you
a
get.
control of function. So they have to
3 and 4. Even that they will not look into. Their own petition. Yes.
May I please?
Yes.
Unlisted to order 30 July 2025. So the order of transfer is under challenge before my lords.
37.
30th July 2025. Lords may see, I am at serial number 26.
26.
Yes.
How many years you have been there?
Here, I have not years, my lord. What has happened? This is a transfer on representation.
Transfer on
representation. I have not filed in representation, but I have been transferred. Lords may see that why I am saying this is on representation. Lords may see page 14. 1-4, my lord.
Transfer has been made
in his own request. That no TAD is allowed.
Shall be admissible. Similar matters we have stayed because he says that I have not made any request at all. And that apart, no TAD is
yes.
Giving insult to the injury.
And also to that effect, may I submit, my lord? I have also filed a representation before the director stating that since I have not filed a representation, how I have...
Let them consider that
yes,
representation we will retain in the consideration.
Yes, but that
31/7.
Yes. Your representation is dated?
At 31 July 2025, my page 15, madam, annexure 3.
This transfer order is dated?
30th July, madam. Just day after.
Very next day you have made that?
Yes, ma'am.
The short grievance of the, kindly be seated. The short grievance of the petitioner is as to, these are her transfer pursuant to transfer notification dated 30 July 2025 wherein her name figures at serial number 23.
26.
Serial number 26. 26. First one. She has been transferred from Government High School, Osakana, Balikuda, Jagatsinghpur
district.
Bhattamangala Government High School, Gopalpur, Jagdishsinghpur, Vasudev Jena. First. Next paragraph. Learned counsel for the petitioner submits that his client has never made any request for such a transfer at all, and that her representation in that connection for annulling the transfer in question made on 31/7/2025 at Annexure 3 remains unconsidered. First, he also points out that since the authorities wrongly assumed the transfer to be on request, even TADA is made inadmissible to the petitioner, and therefore this court should come to the aid of his client. First. Next paragraph. Learned AGA on request accepting the notice for the OPs fairly agrees to instruct his official clients to look into the grievance of the petitioner, as has been heard in the subject representation, if all contentions are kept open. First, with this proposal, counsel for the petitioner is agreeable. First, next paragraph. In the above circumstances, petition is disposed of. Time for consideration of the representation is 4 weeks. 4 weeks. First up, till consideration takes place and result of consideration is informed to the petitioner in writing, she shall be continued in the same place wherein she had been working prior to the transfer order. Course meetings. Next.
Item 9.
May I please manage?
Yes.
But the husband of the petitioner, while working as ex-headmaster and Sebak Primary School, Anjali, in the district of Raigada, he died, my lord, in the side service, my lord, on 4/3/2022, my lord.
Terminal benefits are not given.
My lord.
Terminal benefits of the husband.
And that is not given. Therefore, I filed a petition. But with claim.
Fall between the mother and the wife.
Mother and the wife. But family pension is payable to the wife.
Right, my lord. As per my lord, a family pension, wife is entitled. But see, mother is also, my lord, family pension.
Next year, 4 is there, my lord.
Our husband also working government teacher, government
was 13. That is the impugned daughter of my learned friend.
4 and 6, my lord. 4 and 6, my lord.
There is no state administrative tribunal.
No.
Yeah, that was there, but 2018 it has been wound up.
Abolished.
Sorry, 19.
Now there is a dispute between mother and the widow.
This suppose the impugned daughter concern, they have stated you both settle the dispute outside or anywhere else. Thereafter come to the
What they should do?
That is,
they have to settle the dispute.
And they are not also producing the documents, bank passbook, these are the things.
Now every document has filed, my lord. So for Annexure 4 is concerned, my lord, impugned daughter, they have
the rules. If there is a dispute, how it should be resolved? Which are the rules? In Karnataka, we have rules. Do you have rules?
We have some person.
You accept notice. AG is requested to accept notice for the OPs. Call this matter after 2 weeks, since it pertains to claim for terminal benefits of deceased employee. feelings.
My perspective, prayer also, my lord. If my mother is entitled, then she may be given, my lord. So my entitlement is by my given. So, but
My lord,
Let them come
so
with
far as
some-
apportionment is concerned, my lord, 4 is to be noticed.
private party mother-in-law.
OP4.
My lord.
Yes, brother.
By
I have
restitution.
gone through the book. Comfort. I thought that you have completed the reading itself. Anyway, give that back. Take that book.
Opposite party of 4, my lord, private party, I may be noticed, my lord, by resti post.
Yes. Next.
Post for
Speed post. Now, would you are like?
Speedest to post.
Obliged.
Item 10.
Dear
Yeah.
Lord, last occasion Maharaj was directed to take instruction. So here another application is pending. Wherein the order of status quo is there. For that purpose, this could not be. May I pray that matter may be tagged off by that it will clarify and he will get the relief out of
That's
that.
right. Call this petition along with.
My lord.
There is another coordinate petition.
Yes, sir. That matter, my lord, page 23. I file a modification. My lord, what?
Let it come.
Sir, page
Let
23.
it come because one of the person has filed this application.
Page 23.
Another person who is
Where I filed
number
modification.
4, he has also filed the application and obtained the order of stay. By virtue of that stay order, neither he could be accepted to join there or not. So let it come together. By that it will be finalized.
What happened to your application?
Sir, there I filed a back modification of order.
What happened to that?
That annexure 11, page 23.
What happened? You don't want to answer.
That present application has been filed.
Pending, that is pending.
Present application is pending because they are
This
only.
matter and that matter have to come same bench. It is also before
For
the.
this bench. So this will be convenient to dispose of this bench.
Because there it has been clarified that.
Along with the number 27149 of 2024 in the first week of September. Also. Next.
27149. 27149.
27149.
Man, that matter.
2263. 14. I have done the same one. Oh. Yes.
Item 11. May I please, my lord? My lord, dispute between two truck owner association, my lord, which were resolved under the chairmanship of Subcollector, my lord, under Annexure 3, my lord.
What's your prayer?
My lord, to comply with Annexure 3, my lord. My lord, wherein it was decided that 35% of the ask loading and transportation will be done by the members of the petitioner association, my lord. And rest 65% of the ask loading and transportation.
That resolution dated 13/5/25 needs to be implemented, my lord. To take a decision in that regard.
No, that subcollector will take a decision. Subcollector.
Yeah, but he has to take a decision. But petitioner has presented this petition. Petitioner is knocking at the doors of the court with the following prayer. First, learned counsel for the petitioner on being asked submits. His short grievance would be as to non-implementation of resolution dated 13/5/2025 at Annexure 3. So that the dispute between two associations of truck owners is resolved by OP number.
Well, OP number, my lord, 4.
OP number 4. First one. Next paragraph. Learned AGA appearing for the OPs initially resisted the petition, saying that dispute is civil in nature and therefore party should approach the civil court. Maybe with the aid of this resolution. First, having so contended, now he fairly agrees to instruct OP number 4 to look into the grievance of the petitioner in the light of resolution, subject resolution in a time-bound manner, if a reasonable period is given and all grounds are kept open. First, he also adds that the cooperation from the rival parties is also necessary for taking a decision. First, with this proposal, counsel for the petitioner, you are agreeable? My lord. Counsel for the petitioner is agreeable. First, in the above circumstances, petition is disposed of. Time for compliance is 8 weeks. First, all contentions are kept open. Parties to the stakeholders to cooperate in the implementation of resolution dated 13/5/2025, if decision is taken by the jurisdictional authority. First, it is open to solicit information, etc., from the petitioner or from other stakeholders, if any. So, no points.
Item
clear?
May I please?
Yes, sir.
Madam, the petitioner applied for
What's
custody.
your prayer, brother?
Prayer, my lord, to dispose my appeal, which is pending.
That's the appeal number 20.
My lord.
How many years they want to keep it?
5 years. 5 years, man. Since 5 years.
5 years over.
My lord.
It's a Panchavarshika Yojana.
My lord.
Okay. The short grievance of the petitioner is as to long pendency of caste appeal number 4 of 2020, pending on the file of
before the collector
cum appellate authority.
OP number?
Sole opposite party.
Pending on the file of opposite party. First up. Now the counsel for the petitioner submits that right to speedy remedy is a facet of Article 21 of the Constitution of India in the light of a catena of decisions of the apex court, and that the caste status plays a vital role in the matters of admission to educational institution, public employment, re-election, etc. And therefore, appeal of the kind cannot be kept pending indefinitely. First off, there is force in this submission. Next paragraph. Learned AGA appearing for the OP opposes the petition, contending that the OP has to discharge many statutory duties ex officio, and therefore the hearing of appeals of the kind would take some time. First, having so contended, he agrees to instruct his client to hear and dispose of the appeal as expeditiously as possible, and in any event within a period of 6 months.
6 months, too long. 2 months.
2 months. You want him to commit suicide?
Yes, also.
He will bring that order sheet to my chamber. All contentions are open.
My lord,
Petition disposed.
2 months, my lord. 2 months.
6 months. Outer limit of 6 months. 5 months. Next.
Item 13.
Item 13, may I please, your lordship?
Item 13.
Item 13, may I please, your lordship? I'm appearing virtually, your lordship.
Similar matters we have already admitted.
That notice.
Yes, your lordship. Notice was issued. If I may pray that they may be tagged along, your lordship.
OP, see that who are the parties?
Your lordship, opposite party number 1 to 5.
1 to 5, all governments.
Yes, your lordship.
Except number 5.
Principal is also of a government college, your lordship.
Also, you have taken notice. Other Mr. G took notice for principal also other day.
Yes.
For all OPs, call this matter along with WP number
21845.
21845 of 2025.
Your lordship.
Yes, next.
May I please?
Yes, sir.
Madam, praying for correction of the petitioner father's name in matrix.
Father's name in document.
In matrix certificate, my lord.
Matriculation certificate.
Page 10, my lord. At the time of admission, my lord, the petitioner produced in the school, my lord, is birth certificate.
Only name, not date of.
No, my lord. Only name one letter, my lord. His name is Padmaneshwara, P-A-D-A-N-E-S-W-A-R. Only H is added. In certificate, page 12, my lord. Mark sheet, my lord. Yes.
Emergent notice. Who is the?
Who is the board, my lord?
You appear for the board.
Let him solve copy.
Yes. Can I direct you to consider this? Petitioner is.
Once I will take instruction.
You want to take instruction? Okay. But representation is made.
Yes, ma'am.
You consider it according to law. We have made similar orders already. I will say that you have opposed the petition. All right.
Let him appear.
Let
him appear.
Okay.
Next week.
Learned panel counsel C accepts notice for expedition notice. Learned panel counsel accepts notice for foreign. So AGF.
My note became on behalf of SS Rao.
Becomes on behalf of SS Rao. Okay. And you are for?
1, 3, 1, 3 and 4.
One
except 2
for AGA. 2 is Mr. Rao. Okay. Call in first week of September. Yes. Item 15.
May I please, Your Lordship? I'm appearing through virtual mode of my Lordship, item number 15, my Lordship. My Lordship,
Yes.
what has happened? My Lordship, the petitioner is a developer. He has developed a project in Puri, my Lordship. Thereafter, completed the project and handed over it to a society, my Lordship. After that, in the year 2023, my Lordship, Orissa Apartment Ownership and Management Act 2023 came into picture, my Lordship, wherein, my Lordship, certain powers were conferred upon opposite party number 2 to adjudicate dispute where there is non-maintenance of the apartment about the financial conditions and, my Lordship, constitution of the society, my Lordship. May I apprise the relevant section of the provision, my Lordship? My Lordship, section number 23, Odisha Apartment Ownership and Management Act 2023, my Lordship.
You have made a representation.
Yes, my Lordship. Annexure 5, my Lordship, I have made a representation before the opposite party number 2 to adjudicate the dispute, my Lordship. This kind of dispute has to be adjudicated by opposite party number 2, my Lordship, pursuant to Odisha Apartment Ownership Act 20, Ownership and Management. Pardon?
Under section
23, my Lordship.
Your representation is dated?
My Lordship, 16/9. 16/7/2025, my Lordship. 16/7/2025.
25.
Annexure 5.
Annexure 5, my Lordship.
Who is your opponent?
Opposite party number 3, my Lordship. They are not opponent, my Lordship. They are the association, my Lordship. Opposite party number 2 had to adjudicate the dispute that to look into this.
Look into that representation.
That the PKRD, Puri Kodak Development Authority, the separate
authority is there.
I am for one.
Authority declared.
Okay.
Development Authority, madam.
You appear for?
For one, madam. Government, madam.
AAC for 1. Emergent notice to others. Returnable within 2 weeks, 3 weeks. Next. Item 16.
With the petitioner, working as a headmistress of an aided institution, challenging the legality of the order passed by the OP number 3 and Annex 10, page 62, whereby the OP number 3, without following the statutory rule governing the field, reverted the petitioner from the post of headmistress to the post of assistant teacher, and in her place, OP number 4, who is 13 years junior, has been appointed as a headmaster in charge.
Your appointment is as?
Headmistress in charge, one that is Annex 2.
In charge?
In charge. Because as per the circular governing the field, the senior most staff will be the headmaster in charge or headmistress in charge of the aided institution. And in view of Annex 1 circular, I have been appointed Annex 2 as a headmistress, being the senior most staff.
When you were appointed?
Appointed on 28/12/2006, Annex 2, page 24.
28/12/2006.
My lord.
No regular appointment as last 20 years.
No, my lord. Thereafter, my appointment was approved, Annex 3, by the very same OP number 3.
And they also?
Yes.
approved as a regular candidate or only in charge?
In charge. Kindly see annex, page 26. Serial number 1.
Now you are removed by whom?
By the OP number 4, who is serial number 4, whose appointment 2007, my lord. My appointment 94 as assistant teacher. I have been appointed as headmaster since 2007. Only
issue emergent notice.
May I submit? But there are similar allegations which is not anyway, complying while the authorities are trying to comply with this honorable court's different order, my lord. And he has also, my lord, lordship kindly glance to page 61, my lord. 61.
But did you give any notice to him?
Yes, my lord. That I am placing, my lord. This is the
you take notice and file objections.
My lord.
An allegation is, my lord.
Yes. Nothing can be done. Issue emergent notice. AAC is requested to accept notice for OP number.
OP number 1 to 3.
1 to 3. Emergent notice to
OP number 4.
OP number 4.
I have filed in
second week of September, third week of September 2025. Yes.
I have filed an interim application, my lord.
Interim application will consider. Now there are allegations against you. You don't have right of lien at all. It is only in charge.
Because, my lord, you also kindly see.
If I reject that, observing that will be problematic. So keep it that way. Let us see.
Let the I will lie over, my lord.
That's what.
Item 17.
My lord, petitioner's queries for regularization of a service, my lord. Petitioner was initially appointed as gardener, my lord, on temporary basis. Prior to his appointment, Annexure 1 was issued, where a decision was taken. Page number 21, my lord.
He has been regularized now?
No, my lord, he has not yet been regularized now. He has been working on temporary basis as gardener since 1/7/2014. Till date, he has not yet been regularized, my lord.
Where is your representation?
My lord, in similar matter, notice has been issued, my lord.
Why notice? Will direct the consideration of
because immediately after the consideration of representation, they will terminate him. But they have already
say that you will not be terminated for a period of 1 week after informing you the result of consideration.
My lord, because in similar matter, this honorable court has issued notice and directed and as an intermeasure directed that no coercive action shall be taken against the petitioner. And the petitioner has been appointed in pursuant to advertisement under Annexure 2 series.
Appointment pursuant to Annexure.
Annexure 3 is the Annexure 4 is the appointment letter. Annexure 1 is the HPC resolution where it was proposed to appoint one gardener for both MS Law College and Utkal Law College, University Law College on a consolidated salary.
Emergent notice. Interim order to continue the petitioner in employment with the same terms and conditions till next date of hearing. First off, this interim protection is granted on the assertion of counsel for the petitioner that in similar matter, that is in WP number.
WPC number 10654 of 2024, my lord. This is the order.
Only you have to say so that we can write down, na? Yeah. Part of you should develop the skill of communication. Okay. Say it again.
My lord, WPC number 10654 of 2024.
24.
Order dated 8/5/2024.
First, call this method along with the said regulation.
I am from opposite part 1 and 2, my lord. Rest notice.
Yes, my lord.
Notice to
opposite part number 3 to
1 and 2.
1 and 2. You take notice for 1 and 2.
1 and 2, my lord.
1 and 2. Notice to the rest. Okay.
Item 18.
Yes.
The petitioners are level 5B senior teachers in the elementary cadre.
Yes.
But they seek promotion to level 4 graduate teachers because under the rules.
Similar matters we disposed of. Which is that matter?
My lord, here, my lord, my representation is under Annexure 5, which is addressed to the District Education Officer, Kalahandi.
Petitioners are kindly beseeching. Petitioners are knocking at the doors of High Court with the following prayer. First, next paragraph. Learned counsel for the petitioner, having argued the matter for some time, submits that Already his clients have made a representation dated 16/5/2025 to OP number three. And if that is considered, they will be satisfied. First off, he also says that although right to consideration is not that coherent, but right to be considered for promotion is justiciable. First one. Next paragraph. Learned ASC appearing for the OPs, having resisted the petition for some time on the ground that no employee can lay a claim for direct promotion, now agrees to instruct OP number three to look into the grievance of the petitioner as has been heard in subject representation in a time-bound way if all contentions are kept open. First one. Next paragraph. In the above circumstances, petition is disposed of, fixing a period of 3 months for consideration of the subject representation and also to inform result of such consideration to the petitioners individually in writing.
Yes.
First up. It is open to solicit any information, document from the petitioners or any other departments. No, no course.
Item 19. 19, my lord.
Yes.
Petitioner is working as a lady matron, my lord, contractual basis. Now she is claiming for regulation after completion of 6 years. You're looking at government notification 12/11/2013, my lord.
12/11/2013,
my lord.
What it says?
After completion of 6 years, he may be regularized, my lord. Your lordship can say NS 3/21, my lord.
Similar matters we have treated. You have given representation.
No, my lord. Guideline, my lord.
Guideline, all right, but you should inform the government. You have to.
Your lordship can NS 3, my lord, 21, my lord. Condition service was regular appointment, my lord.
No, that is the rule. But you have to tell the king. King, the rule is like this, you have to follow. That is the system we are living in now.
Notice me with
what will happen to
similar
representation?
No, my lord. No, lordship always similar notice has been issued.
That's all right, but you give a representation. We don't know what is happening in that matter.
Same matron, my lord. Same matron.
Maybe, but still, you have to see, if you seek mandamus, the rule is any standard book on writ of law of writs like your B.L. Hansaria, V.G. Ramachandra, D.D. Basu. They say, if you seek mandamus, you should make a representation.
No representation pending, madam.
No representation is made. I will permit you to make the representation.
Similar matter already, your lordship already notice.
Petitioner is invoking the jurisdiction of this court with the following prayer. First off, when asked as to whether any writ of mandamus can be issued, there being no demand and rejection, the petitioner only quotes that similar matter is already notice has been issued, and therefore in this matter also notice should be issued. First, this court does not agree with that proposition, law being what it is. First off, in the above circumstances, petition is disposed of, permitting the petitioner to make appropriate representation in terms of subject rules, seeking regularization, and if one is made, the jurisdictional OP shall take a call on the same within an outer limit of 3 months. First off, in that connection, all contentions of the parties are kept open. Yes, next. No,
21, my lord, same, my lord.
21 also same?
Yes, madam.
Same.
My lords may grant some more time, 3 weeks.
3 months?
3 months.
Yes.
May I pray?
Yes.
Item 20.
When the present writ application petitioner challenging the drone survey report. It is 16
Mr. Swain, I have one small request to you.
Yes.
You senior advocates should conduct classes for youngsters once in a month, free class, maybe service law, education law. In Bangalore, we used to do it.
Yes.
We used to organize training programs for youngsters where very prominent advocates will come on their own.
Yes.
And they will take class for these people so that they also get improved.
Yes.
Otherwise, the whole bar will be in the fist of very few.
Yes.
What should happen to other liars? No social justice will be done.
Your Lordship, suggestion is very good.
But instead of having judges lectures, lectures nobody entertains now. They are not entertaining. They are boring.
Yes.
Therefore, you seniors, I make request. You seniors take some classes, maybe 5%, 10%, not class like also, interactive session.
Yes.
Sitting around.
It is one type of interaction.
Interactive session. That's the best way.
Yes.
Lectures, nobody will listen.
Yes.
They will simply clap without knowing what is being said.
Yes.
Therefore, participate in interactive sessions. That helps the bar.
Yes.
Improves the quality of the bar. Okay.
Yes.
Yes.
My Premi.
Yes.
This is the internal challenging the drone survey report.
Drone survey report?
My lord.
Of your land?
No, I am a lessee.
You are a lessee?
In my absence, my lord, the drone survey was conducted. No notice was ever issued. Then I filed a representation that the drone survey conducted in my absence. So you consider it again. That application is pending by Annexure 5.
How if drone survey takes place?
Because my lord, my EC was expired on 16/1/2025.
Your
lease for a period of 5 years of Blackstone Quarry.
It was for 5 years.
5 years.
From which date to which date?
From 21 to 26.
You don't have date at all?
Well, I have date at all.
Because that culture I am not seeing. Therefore, I am asking.
No, Lordship, can you see Annexure 1, my lord?
I don't see that. From which date?
23/7/2021.
23/7/2021.
21 is the grant, my lord. But lease deed is executed.
Lease deed is executed on?
Lease deed is executed on 14th day of November 2024.
November 14?
24, my lord.
24.
My lord, as per law, my lord, I have to operate the lease for a period of 5 years, my lord, from the date of execution of lease deed.
It is 5-year lease.
5 years lease. And that lease is valid today. My EC was expired on 16/1/2025. Environmental clearance.
Environmental
clearance was expired on 16/1/2005 because EC was granted for a period of 2 years. Thereafter, I had stopped the operation, my lord.
EC expired on
16/1/2025. Then, my lord, the Odisha Space Application Center, who is the nodal agency of the state government to conduct the drone survey, on 28/2/2025.
What form they conduct the survey?
They have conducted a survey with regard to excavation of the Blackstone mine. Lordship, kindly see page 50, my lord, that is the report.
Your lease is still in operation?
Lease is still in operation. But this report is prejudiced me, my lord. That was because the drone survey was conducted in my absence. No notice was ever given.
What you would have done if an opportunity is given to you to the drone survey?
No.
If it is on the actual survey on ground?
No. In fact, there is no actual survey, my lord, because there is some adjacent land, the lessee, my lord. So there was also some adjacent lease, my lord. So from which lease they have taken the drone survey?
No, you take drone survey report and file objection to that. How drone survey? Should you be taken along with the drone?
No. They have given a finding that I have excavated beyond 6 meters from the lowest area.
You challenge that. You file objection to that.
My lord, I have also filed a representation, my lord. I had Annexure 5.
Consider the representative.
My lord.
The drone survey should be given up.
My lord's only case is that in his presence it was not done, not that he is challenged.
He need not be presented. Drone survey is a different concept. It's a real survey.
He can file objection to the findings of the survey
report. You can file.
I have filed the representation, my lord.
You have filed that.
My lord, Annexure 5.
Representation for his presence, it should be resurvey in his presence.
No, I am also denying that.
Anyway, you filed.
My lord, I have filed.
That resurvey cannot be directed. Now survey is already done. It is drone survey. But we will give you permission to file the objection to the survey report. Thereafter, decision will be taken based upon everything. All right. Perfect. Petitioner's prayer reads as next paragraph. Learned counsel for the petitioner argues that the land in question having been allotted, kindly be seated, allotted on 23/7/2021, a lease has been executed in his favor in respect of the land in question on 14/11/2024 with a tenure of 5 years. He also tells that the environmental clearance certificate expired on 16 January 2025 and that now the drone survey has been accomplished without giving an opportunity of hearing to him. First, he points out that on the basis of drone survey report, some adverse action may follow and therefore he has made a representation dated 3/7/2025 at Annexure 5 for undertaking the exercise de novo. First, next paragraph. Learned the AGA on request appearing for the OPs opposes the petition, contending that if the ground survey is to be done, hands are involved and instruments are involved, and therefore presence of stakeholders may be required. When drone survey is undertaken, it is a kind of aerial survey, and therefore, if there is any difficulty, it is open to the stakeholder to file objections to the survey report of the kind, so that the concerned authority would address the objections and take a decision on a normative basis. First off, next paragraph. At this stage, learned counsel for the petitioner requests the court for some time so that his petitioner is inclined to file the objections to the survey report. First off, with this proposal, learned AGA is also agreeable. Next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to file his objections to the drone survey report within a period of 2 weeks, producing all vouching material in support of the objections, and that till a decision is taken by the jurisdictional OPs on the said objections, no coercive action shall be taken against the petitioner solely on the basis of the drone survey report. First, all contentions are kept open. Petition disposed of. No, bless.
Item 22.
Yes. Well, this matter relates to the constitution of the managing committee. Well, the term of the managing committee became over on 3/6/2025. It was approved on 3/6/2022 under Annexure 2.
3/6/25 it expired.
Well, as per Rule 27(1) of the Management Rules of 1991, my lord, for reconstitution of the managing committee, the outgoing managing committee is required to submit proposal 90 days prior to expiry of its term.
90 days, that should be 3/3/25.
Yes. And accordingly, your lordship may kindly turn to Annexure 5. A proposal was sent by the outgoing managing committee on 17/2/2025.
No decision is taken on that.
My lord, no decision has yet been taken. My lord, it has been sent to the district education officer, who is required to verify the proposal, and thereafter he will send it to the prescribed authority for approval in terms of Rule 27(4). Now it is pending with the district education officer.
Let them consider.
Let them consider.
Okay. Thank you, Dixit. The tenure of the managing committee in question in respect of the educational institution having expired on 3/6/2025, some process needs to be undertaken in terms of Rule 27(1) of management rules. Give that. Yes. Management rules, so and so, so and so. Learned counsel for the petitioner, drawing attention to the representation dated 17/2/2025, submits that under the extant rules, the proposal for the formation of new committee has to be sent 3 months in advance to the expiry of the existing committee.
Yes.
And that having happened, no decision is taken on the proposal. First. Next paragraph. Learned AGA, on request appearing for the OPs, agrees with the proposal of this court that the subject representation dated 17/2/2025 at Annexure 5 needs to be treated by OP number?
OP number 3.
OP number 3 in terms of the provisions of Rule 27 of the rules. And the paper should be placed at the hands of
OP number 2.
OP number 2 for grant of approval.
Yes.
First of all contentions in that regard, he submits, be kept open. First of next paragraph. In the above circumstances, petition is disposed of, fixing a period of 8 weeks for accomplishing the mandated task. First off, it is open to solicit any information, etc., etc. No, gods. So, Item 23.
Here is the matter relating to grant of arrears salary of the petitioner as against the post of peon for the period from 1/12/2003 to 29/4/2015 in view of the judgment passed by the Honorable Apex Court in the case of Rajendra Kumar Das, which has been subsequently clarified by the Honorable Apex Court in SLP 7197/19, disposed of on 16/4/24. For that matter, I have already made a demand before the OP number 2 matter on Annexure 7.
Annexure 7.
7. Dated 18/8/2024.
18/8/24.
24.
8. For the period between
1/12/2003 to 29/4/2015. Because I have been extended from 30th April 2015.
29/4/2015. Arrears of salary.
Arrears salary.
Differential of salary.
Total area. They have not paid.
Given any amount at all.
Not paid any.
You worked during that?
Yes. That issue has been settled by the Apex Court with regard to that 4th peon matter. And now subsequently when the Apex Court also clarified the area salary is to be paid. You also kindly see the Apex Court order. The latest order by which manner I am made a presentation.
You consider the representation in the light of Apex Court order?
My lord,
AGA?
my lords, but the mode of communication is not there. So whether it is filed or not.
I have filed.
How you sent that representation?
I have sent my lord to before the OP number 2.
How?
Appear before the OP number 2 on hand to hand in the given cell.
Where is the counter side?
They have not given my lord. Because
where have you stated? Despite my giving this, they refuse to grant the seal.
That I have not stated.
Then you give one more representation.
One more representation.
Okay. Be seated. Petitioner has scripted his prayer as under. First off, learned counsel for the petitioner submits that in the light of apex court decision in State of Odisha versus Bhattaranjan Dixit.
Original order, my lord.
Why have you copied my name? In civil appeal.
This is the original judgment. Thereafter, it has been clarified in the subsequent judgment. Both the judgment also kindly report. That is the main judgment reported in 2003 SCC, my lord. 10 SCC.
Learned counsel for the petitioner. First part, let me read. Learned counsel for the petitioner, drawing attention of the court to the apex court decision in State of Odisha, correct? Versus Rajendra Kumar Das. This is not Dixit. Das. Manu SC 0643 but 2003.
2003, 10, volume 10 SCC also reported.
Reported?
Yes.
What is that till 2003?
Volume 10 SCC.
Probably. 2003.
Volume 10 SCC.
10 SCC.
Page 411. 411.
411. 11. Followed by the clarification made in SLP number 7197 of 2019 between State of Odisha versus Bhattaranjan Dixit, disposed of on 16/4/2024, the jurisdictional OP ought to have settled the arrears of salary for the period between 1/12/2003 and 29/4/2015. First, he further submits that despite giving a representation dated 18/8/2024, a copy whereof awaits at Annexure AA,
S7. Annexure 7.
7. Annexure 7. No decision is taken, and therefore interference of this court is eminently warranted. First of all, learned the AGA on request accepting notice for the OPs opposes the petition, contending that there is absolutely no proof that the petitioner has given the subject representation, and therefore he may be permitted to give a fresh one so that the jurisdictional authority would make a decision thereon in a reasonable way, in a reasonable period, and in accordance with law. First off, with this proposal, counsel for the petitioner, you are agreeable? What counsel for the petitioner is agreeable. First off, with the above observation, petition is disposed of, giving liberty to the petitioner to make the subject, make appropriate representation supported by evidentiary material within 2 weeks. And if one is made, the jurisdictional OP to take a decision thereon within 8 weeks next following. First off, in that connection, all contentions are kept.
Keeping in view that judgment. Keeping in view that judgment of the Supreme Court.
It hardly needs to be stated that the decision in contemplation shall be considered keeping in view the aforesaid orders of the apex court. Item 24.
Item 24, please, Your Lordship.
Yes.
Your Lordship, the present writ application has been filed challenging the illegal and high-handed action of the opposite party number 2, which is a statutory body governed under the Odisha Municipal Act. Your Lordship, the opposite party number 2 have attempted to establish some vending zones in the eastern side public road, which is just adjacent to the petitioner's scheduled land. And
it should not be established.
Your Lordship, we have made a representation before the concerned authority, putting into reliance the Honorable Odisha High Court judgment in Lal Bihari Basa versus Vijay Kumar Mahota. In that case, Your Lordship,
what they have said,
it has been decided that the owner of
to access.
The owner of the land, it is a natural right and right in rem to access every boundary, every point of the boundary. And even if there is an alternative access to the still that right is available with the petitioners.
That representation to be considered.
Yes, they have not
the authorities to consider.
And the NSE has initiated that vending zone thing in front of the house, and we have made a representation on 29/7/2025, Your Lordship, to the concerned authority, NSE authority.
NSE means?
Notified Area Council.
You appear for this?
No,
they are separate issue. Emergent notice. No, state is not a party.
State is also a party.
OP number 1 by AGA. Emergent notice to other OPs.
Your Lordship, an IA has also been filed today for.
We will not halt that process. Let us see. Return a post immediately after service. Item 25.
May I please, Your Lordship? May I please, Your Lordship? Here, my lord, the petitioner has challenged the impugn order on the Annex of 5, my lord. Annex of 5, my lord.
What is that?
Annex of 5, page 18, my lord. The deployment of the following teachers by this office order number 1238 dated 7/3/24 is hereby cancelled. They are directed to join in their parental post immediately, my lord. Without assigning any reason, my lord, this order has been passed. Your Lordship,
deployment is a transfer. What is the deployment of the following teachers made by this order to here be cancelled? What was the deployment about?
In pursuance to representation under Annexure 2, my lord.
They were deployed to do what?
She was deployed to work at Harabanga block, my lord. Harabanga block.
How many kilometers?
50 kilometers, my lord. That is 50 kilometers, my lord. In view of the fact that the petitioner's mother-in-law is a orthopedic and kidney patient, my lord. She has 2 years and 6 months child, and her husband is also working at Harabanga block, my lord. That's why she submitted a representation to the opposite party number 4 under Annexure 2, my lord. And her representation, after being approved by the collector under Annexure 3, my lord, she was deployed and she was asked to go to Harabanga block and join at, my lord, Annexure 3, my lord. She joined at Puruna Katak, nodal offer primary school, my lord. On the Annexure 3, your lordship, my kindly see page 16, my lord, running page 16.
You want the all of a sudden it will change?
Yes,
may I Annexure 3. Can I have a glance to 7/3/2024? It is an order of deployment on the ground of administrative exigency to that particular place. After a lapse of more than 1 year, Annexure 5 is the impugned order wherein out of 4 persons, 2 persons has been returned back to their original place where they were engaged. That is the order.
No. Now the spousal ground is also there.
Yes.
And that is the representation mill. But so far this 2024 order is concerned, 4 persons to deploy to different schools, Miller.
Correct.
And after a lapse of 1 year, they have returned back to their original place. It cannot be
deployment is 1 year.
1 year, Miller, because it is a 7/3/2024 order.
No, where does it prescribe 1 year deployment?
No, Miller, 1 year, it has not been specified. Can I have a glance to page Annexure 3, Miller, page 16.
After due approval,
hereby deployed to schools mentioned against their names on administrative exigency. It is a transfer order.
Yes,
whatever word you may use.
For a particular period, Miller.
Where is that?
So, that has not been specified.
Then you can't say it's a deployment. It's only calling 6 as a half a dozen. Makes no difference. It's a transfer order only.
So thereafter they have filed this representation which is pending with the authority on the spouse ground and on the medical.
No, on spousal, when see our system, is it expects that husband and wife should be staying together. Unless government wants to intervene between them by this order.
Spouse.
Right to reside, right to conjugal happiness. These are all the rights which human beings will have. On that basis, the policies of spousal policies are made. Then all of a sudden now, if you make them dissociate from each other, where they should go? Disrupting family is a serious matter.
It is around 40 kilometers per second.
50 kilometers.
That's all right. What is the reason for this? Saying that administrative exigency, public interest, they sound very, very hollow. What is that administrative exigency? If services are required, is Saram Vishwashraya, and therefore you have to build another Bhakra Nangal, therefore exigency, therefore I can understand. Is it you are a teacher?
Yes, ma'am.
You are a teacher.
Junior.
Any complaint there from the students? I heard that you were not teaching well. Will issue stay? Issue.
My lord, let them consider
the
that
representation.
Till then,
Okay. Petitioner has scripted his prayer as under. First one. Learned counsel for the petitioner submits that the impugned order disrupts the policy relating to spousal retention, and that within a short period, petitioner could not have been displaced on whimsical way. First off, learned counsel also draws attention of the court to the representation dated 13/8/2025 at Annexure 6 series, wherein he or she has sought for retention in the same place. First one. Next paragraph. Learned AGA appearing for the OPs opposes the petition, contending that in terms of Apex Court decision in Varadhara versus State of Karnataka, the employees of the state are not exempt from transfer, and that they are required to work wherever they are posted on the basis of exigencies. First, having so argued, now he agrees to instruct his client to look into the grievance of the petitioner, as has been aired in the subject representations at Annexure 6 series. 6 series?
Well,
6 series. And 6 series, if all grounds are kept open. First off, with this proposal, counsel for the petitioner is agreeable. First off, next paragraph. In the above circumstances, petition is disposed of. First off, the jurisdictional OP to take decision on the representations, on the subject representations, and till such a decision is taken and communicated to the petitioner, petitioner shall not be displaced from the place, shall not be disturbed from the place wherein she has been presently working. No cause.
I will bother you, Lordship. With item 35, 97 matter. First time coming after 10 years, I have misplaced the file.
So you get the file from our registry.
I'll get it from registry. Lordship will pass appropriate.
Registry to furnish the pen drive file to the council appearing for the petitioner, sir. Call week after next.
Commencing?
Week after next.
This is we have two working days. Week thereafter.
Week after next.
20%.
I won't hear. 20%.
Well, this was disposed upon 28/11/2024, and it has been sent to the record room also.
No, that was restored.
It's restored.
Yes.
We have not been supplied with the
just looking. Awesome.
Password.
Password.
Item 4.
May I excuse me?
Yes, sir.
May I please, my lord?
Yes.
Well, the petitioner in this instant writ application seeks a writ of quo warranto, questioning the authority of OP number 4 to hold the post of the principal in the College of OP number 3, my lord, despite an audit report being submitted against him, finding him to be implicated in serious financial irregularities, misappropriation, etc., my lord. Your lordship would kindly see Annexure 4 at page 22.
Two things are there.
Yes, my lord.
The idea of co-warranto was treated by the apex court for the first time in C.D. Govindarao, Mysore University versus C.D. Govindarao. There, the person should be holding an office without title. Without title, without right to hold the office.
Yes, ma'am, that's right.
So, as on the date he was appointed,
yes, madam,
they had right to be appointed.
Yes, madam.
And he was appointed.
Yes, madam.
He is holding the post.
He is holding the post.
How he gets the right of being forfeited? By what process?
My lord, yes, my lord, I'll come. My lord, before I take my lord to the question which my lord has posed me, I'll just state in brief the background of the case, my lord. My lord, during his incumbency period for a period of 4 years, 7 months, ranging from November 2018 to June 2023, my lord. My lord, a representation was given by the employees of the college to the government to cause an enquiry. The government caused an enquiry, and thereafter the enquiry was also submitted. The enquiry, my lord, which was conducted by at the government's end by the Director of Education, my lord, found that so far as the allegation of misappropriation is concerned, there is no prima facie evidence to that effect. Howsoever, in public interest, it recommended an audit should be carried out by the government.
Audit?
Yes, my lord. And thereafter, my lord, the government carried out a special audit.
So in the inquiry, he emerged victorious.
With the recommendation that audit should be, yes, my lord.
Yes. Where is that?
Yes, my lord. Your lordship would kindly see Annexure 6 at page 25, my lord. Operative portion, page 27, my lord. Observation and recommendation. The inquiry was conducted by the regional director.
Prima facie, no evidence of financial
misappropriation.
However, in the larger interest of the institution, it is recommended by government by order for local fund audit with regard to financial transaction during the period under question.
Yes. But thereafter, the special audit was conducted by Annexure 6, madam, at page 25.
Yes.
Well, thereafter, the audit was, since the audit was conducted, you will find the audit report under Annexure 11 at page 34, which has been procured under the RTA Act, my lord.
What the audit report says?
Your lordship would see page 35. This is the report has been submitted to the government, and your lordship would turn to page 37. Your lordship would see the OP number 4, Dr. Pradipta Kumar Dahan. His incumbency period was from 13/11/2018 to 8/6/2023, and thereafter from 9/11/23 to 5/11/2023. Then your lordship would see in the audit report, right? The audit report, page 57, my lord. After completing the audit report, it was found that an amount of rupees 1,44,21,965 is suggested for recovery. And one recovery from whom? Recovery from Pradeep Kumar Mohan, my lord. Because this entire audit was only concerning him, my lord. And if your lordship would see the different subjects, my lord. So far as page 43 is concerned, my lord, clause 4, irregular and inadmissible payment made to the GI staff amounting to 68,96,000.
No, where is the ground for removal?
No, not removal, my lord. Not removal. I'll come to that. Why I'm saying that he is not entitled to hold on to the post, my lord. So therefore, my lord, the audit report clearly implicates him asking for a recovery of more than 1 crore rupees, my lord. Now, your lordship would see, despite this audit report, Pradeep Kumar Mohan, OP number 4, files a writ petition before this honorable court, seeking a direction to appoint him to the post of principal. Your lordship would see Annex 15 happened to that. Your lordship would see Annex 15. I'm asking you. I believe there was an innocuous order to consider his representation.
Then what happened?
But I need to point out the counter which was filed by the state and the stand which was taken by the state, which my lord would find at Annex 15 at page 1.
But after seeing the counter, order is made.
My lord, the counter, my lord, they categorically hold that in view of the directions passed by the Honorable High Court in several cases, integrity of the person is paramount, my lord. He may be eligible so far as seniority is concerned, but he should be, his integrity should be clean, my lord.
No, where is the ground for co-warrantor?
Yes, my lord. Co-warrantor,
co-warrantor is a senior.
Yes,
any standard book on
it is, my lord, with me only for a moment, my lord, the ground which has been taken by the state government, my lord, at page 139, the state in its counter to the writ petition filed by the Pradeep Kumar.
There it was disposed of that we directing consideration of the writ petition.
Yes, madam.
The court did not enter any finding on that.
No, madam. But this was the stand of the state.
That may be a case for disciplinary inquiry. How can there be a co-warrantor on this ground?
No, disciplinary inquiry, not disciplinary, but
disciplinary inquiry emerged victorious.
Yes, madam. No, not there was an inquiry. There was no disciplinary inquiry as per the rules, madam, but there was an inquiry. And the government took a stand because of his financial indiscipline and misappropriation, serious allegations of misappropriation of money and all.
On that ground, can anybody?
He is not entitled to hold the post in view of the guidelines framed by the government.
Where is the finding that he has done this on the mere allegation? Nobody will be set to
audit, my lord. The audit is categorical, my lord.
Audit is not a ground.
Now I'll come to the take my lord to the guidelines of the government. Your lordship will kindly see.
Is he found guilty of a misconduct which entails
I'll come to the point, my lord. I'll answer your lordship query that why he is not entitled to hold the post, my lord. And why I'm seeking
should not waste my time because law is well settled right from the days of Govind Rao. Unless you bring your case within the parameters of Govind Rao, I will not grant. I will not go on hearing you. Or you have to make one important.
Lordship, kindly see Annex 21, page 143.
You tell that. I believe you.
Yes, madam. This is the guidelines for posting of principals in non-government aided colleges under Higher Education Department, consequent upon reconstitution of common cadre of teachers appointed recruited against direct recruitment posts for non-government aided colleges by the Department Resolution dated so-and-so. The procedure and criteria for appointment of principals in non-government aided colleges are outlined as below. This is all outlined as below in compliance with the directions of the Honorable High Court in several cases. Now, my lord, the criteria for becoming a principal, your lordship, the tenure has been provided. The tenure is for 5 years, which has come to an end on 21st of this month itself. Now, the eligibility, your lordship, they have said, however, to deal with serious financial irregularities or administrative and academic mismanagement, the eligible and willing reader from the common cadre of readers as stated in for aided colleges will be deployed to such category of colleges. And thereafter, my lord, the conditions which are required. This is important, my lord. That he should not be having any vigilance cases pending against him.
Where is the vigilance case pending against?
No, my lord. No.
Number.
Disciplinary proceedings? No.
No pending.
Or criminal proceeding? No. Audit para is pending against him or her, or he has not been punished / convicted in the past in any vigilance cases, disciplinary proceedings, and criminal proceedings. My limited respectful submission before your lordship is that admittedly there's an audit report which is pending against him.
Report is, we can't say pending. Pursuant to report, something should emerge.
No, but it's the guidelines.
Courts have held already.
Yes, madam.
Yeah, I do not carry library on my back, but there are such judgments.
Your lordship.
No case is made out. Do you want to withdraw, or I should dismiss after considering your contentions? Our best way is you make a representation so that they will consider.
In that case,
it cannot be. It's a very serious writ.
It's a serious prerogative writ, madam.
It's a very prerogative writ which King used to issue in England. Therefore, in most of the high courts, for co-warranto, 2 judges sit. You see, very few cases courts where single judge.
Yes, madam.
Where is the case? You have not made out anything.
Case laws, madam, I have bought a judgment when so far as
the effect.
No, effect in the sense, madam, writ of co-warranto can be filed. This is of
anybody can file writ of co-warranto.
Even though this is what
can be granted is the question.
Madam, another case of Allahabad High Court, madam, where objection was raised so far as writ of co-warranto is concerned. Your lordship, may only point out. In that case, I'll make a representation to the government, madam.
Learned counsel, having argued the matter vociferously for the issuance of writ of co-warranto, now seeks leave of the court to withdraw the petition to make an appropriate representation to the jurisdictional authorities for ventilating his grievance. He further submits that if such a representation is made within 2 weeks, the same shall be met due consideration at the hands of the jurisdictional authorities in accordance with law. First, I agree. First, in view of the above, petition is accordingly disposed of. C.D. Govinda Rao is one of the famous judgments, one of the best judgments on the law of CORAM. In England, there are many judgments on law of CORAM, but our co-warranto stands on a bit different footing. The other day, Mr. Mohanty was arguing that matter. State of University of Mysore versus C.D. Govinda Rao. Just look it, whatever that helps.
Item 26.
My lord, I am the petitioner in this case. I am working as an assistant teacher of Karalangi High School in the district of Kemjar. Although I am a senior man, but I am forced to work under my junior from the year 2019, continuously, one after another. Initially, I joined and appointed as headmaster of that high school in the year 95, 1st of August 1995, when that school was a private school, unaided school. Subsequently, in the year 2024, the school was taken, added.
You want to be put back to the same position?
Yes, sir.
And given representation.
Representation, sir, decisions are there. In this case.
No, I am asking you. Did you ask them, put me back to the original position? I cannot be made to serve under my junior.
Yes.
It is contrary to the tenets of service jurisprudence.
Yes.
Did you give that representation?
Yes.
What happened to that?
What I ordered? I made a representation. The order was passed. Back to me. In the headmaster in charge. What do they say? They said the order. When they passed the order to reverse me back to the headmaster in charge, again the opposite party filed a case here.
The stay has been obtained.
In this court.
So we'll call this matter along with that.
Along with that.
I guess.
You take notice in the meanwhile, Mr. Mohanty, AG and Mr. Mohanty, and the heads up notice for the respondents. First up. A connected matter in WP number. Not your WP, other WP.
Yes, 28476.
28476 of 2025. 23 is said to be pending. Which is said to be pending. On this matter, along with connected matter, which is said to be the third week of September. Yes.
Item 27.
This matter was disposed of, sir. This matter was disposed of.
It's not pending.
No, it is disposed of. holding with a direction that to consider the petitioner and vice versa, the petitioner and the opposite party who is the petitioner now, in between them according to law. But what they did, they again
Continued him.
Again continued him.
You take notice that AGA is requested to accept notice.
So surprisingly, after his death, again this next junior has been taken. This is an arbitrary action of the DO measure.
Who is that OP?
Who is that?
OP number?
OP number. OP number.
OP number.
OP number 5.
Official 1 to 4.
1 to 4 is the official response.
Yes.
5 is the private case.
Yes. 5. Oh.
Item 27.
27, my lord, already passed.
You have rectified everything.
My lord.
Okay. 27. Yes. Yes, sir.
Now, see, in this matter, I am for the petitioners who are successful in the preliminary examination will receives, and pursuant to the advertisement under Annexure 1 you will receive, that starts at...
They should publish the result of main written exam.
Written exam was already over you will receive, but the result has been held up because
Therefore,
of...
you want a direction to publish it.
Lies you will receive.
Who appears for OPs?
There are panel of lawyers, my lord.
Mr. S.N. Patnaik is appearing on...
You appear for whom? OP number?
1.
OP number 1. Issue notice. AGA to appear for OP number 1. Appears for OP number 1.
If they can...
I'm on behalf of S.N. Patnaik for Odisha staff selection.
OP number 2 you will receive.
This panel council accepts notice for
Number 2.
OP number 2. Any other party?
No,
No, my lord. They are the main contesting party, OP number 2.
Yes,
They are declared the result.
When results, why are you not publishing the result?
My lord, we're seeking instruction finally.
Yes, at page 137, I have annexed that order. But towards my grievance petition, they have stated that because of pendency of another writ petition, they are not
Which
published.
is that writ petition?
And I have annexed that order also at that page.
I'll call this matter along with that. Is it before other bench or this bench?
Now this is assigned to your LRC.
To this bench?
Yes, sir.
Call this matter along with WP number
14903 of 2025.
14903 of 2025. If it fits into roster of this bench.
Okay.
Article 29.
In that writ petition also, I am the intervener, LRC.
Yeah.
Item 29, Lordship, I'm appealing for the petitioner. Lordship, in this case, the petitioner is a registered
verification process.
Lordship, what has happened is in the MSME, when we file a claim, the process adopted by them is that the DIC Cuttack, the Directorate of Industries, MSCFC Cuttack, they send a verification to the local Directorate of Industries of the concerned district where the MSME unit is registered. In this case, the MSME unit has been registered in Jajpur, a district of Odisha, and the verification process, a memo for that has been sent by OP number 2, DIC Cuttack, to OP number 1, DIC Jajpur.
Where it is registered.
Where it is registered. It has been pending since, my lord, since 28/11/2024. The petitioner is a registered MSME and he has been facing a lot of issues regarding that matter, your lordship. OP number 1 is DIC Jajpur. OP number 2 is DIC Cuttack. And OP number 3
representation.
Representation is at annexure number 11, page 52, the one which I had sent to DIC Jajpur along with a copy which has been marked to DIC Cuttack. And the memo which was sent by DIC Cuttack to DIC Jajpur asking for the status of the MSME is at annexure number 9, page 49, your lordship. Page number 49 is the letter sent by the DIC Cuttack.
What is your in representation? What you have said? Your representation longer than the petition.
Representation, it has been stated the brief history of the case and that the verification.
Where is your prayer column? your demand column.
In the representation, Lordship.
Page 54.
Page 54, Your Lordship.
54 it begins. It runs
No,
Lordship.
It begins at page number 52.
52.
Yes, Your Lordship.
And runs into.
And the operative portion is at page number 54.
Read.
Page number 54, client is a registered small-scale MSME and he had taken numerous loans to complete the work so awarded to him on the second paragraph. And due to his wrongful and premature evacuation, is suffering grave losses. Therefore, this careless approach of your good office towards the legitimate dues of my client is in complete derogation to the spirit and text of 2000 MSME.
What they should do?
Lordship, that is
we want this to be done. Kindly do it.
Page number 50.
Sir, they have not done, issue it. That should be our half-page writ petition. Your representation itself runs into pages.
Page number
does not make who should do what is not known there.
Page number 53 has stated that a representation.
Write down what you want. You write down now. I will give that direction.
Lordship, my prayer is at page number 9 of my writ petition, whereas stated that the OP number 1 and OP number 2 be directed to complete the verification
process and submit the report before so and so.
Lordship, that is my prayer at the writ page number 9.
The short and innocuous prayer of the petitioner runs as under item number 2. Next paragraph. Learned counsel for the petitioner, drawing attention of the court to the representation dated, long representation dated
31/07/2025.
31/7/2025 at an exert 11 submits that despite demand, the OP numbers 1 and 2 are not accomplishing the verification process and have not submitted the report before the M.S.SAHOO for the purpose of proceeding in the MSME case. What is the case number?
Case number will only be allowed after verification is completed. That is the entire issue.
Filed before the M.S.SAHOO at Cuttack
on 20th November 2024.
On 2011-2024. He also tells the court that because of inaction on the part of answering OPs, his client being a registered MSME has been suffering a hell lot, and therefore interference of this court is warranted. You appear for 1 and 2.
1 and 2. 3 is the private party.
Learned AGA appears for OP numbers 1 and 2 who are answering respondents. Notice to OP number 3 is dispensed with in as much as no coercive order is being passed on merits of the matter. Next paragraph. Learned AGA, in his usual fairness, submits that he would instruct the OP numbers 1 and 2 to look into the grievance of the petitioner as has been aired in the subject representation in a time-bound way if all contentions of the parties are kept open. He also tells that since notice to OP number 3 is dispensed with, there would be requirement of having his say as well in the matter. With this proposition, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, this petition is disposed of, fixing a period of 8 weeks for OP numbers 1 and 2 to complete the subject verification process and submit the required report before M.S.SAHOO Cuttack. First off, it hardly needs to be stated that this process shall be accomplished after giving an opportunity of hearing to all the stakeholders, including OP number 3. First of all contentions are kept open.
Lordship, if I may make a small prayer, if your Lordship may allow me. Lordship, that may the 8 weeks period be reduced because they have been filed.
Because notice has to be issued to the other party. We are not issued. Otherwise, suppose if I were to issue notice, another 3 months would have gone. Therefore, including that, I have done.
Because, Lordship, the claim amount in the case is more than 18 crore rupees. That is my limited fee.
Correct, but like that. Yeah.
Obliged.
Item 30.
Yes, sir.
So, Annex 3 and challenge lordship, the memorandum given by the OP4 lordship, here the issue lordship, the present petitioner is
you are charged in a disciplinary inquiry.
Yes, lordship.
What have you done?
The allegations in the memorandum of lordship, the production of fake certificate, city certificate during appointment.
Certificate.
My lord.
City means?
City means certificates of
teachers training. They want to look into that. How you should not face the inquiry?
My lords, I am coming. Their documents under Annex 3 lordship, they have supplied 2 documents. Page 20 lordship can have a glance. Page 19 and 20. Page 20 lordship, first I invite your lordships. That is letter 251 issued on 17/2/2025 lordship. The assistant from the issuing authority, the Assistant Secretary, Confidential Record Room, Board of Secondary Education, Odisha, Cuttack, where they have issued this clarification lordship. Last para the tabular last line lordship. My roll number is 15F052. Year of examination 1991 city. The name of the candidate, my name is Vaishnav Harijan lordship. The result division grade pass and the remarks is genuine. The same authority verified, searching for the information and that is verified, that is the document is genuine. In the next page, lordship kindly have page 20. Here the same clarification again called for, and on 21/7/2025, the same last portion lordship kindly have glance. The remarks column. Here the everything is right, total marks equal, that is right, result is pass, that is there. But in remarks column, the roll number reflected in the Xerox copy of the certificate submitted by you does not exist in the tabulation register available in the CRR section. Due to these 2 conflicting document lordship, the charges framed against me lordship. And the Board of Secondary Education, both the document issued by the authorities of Board of Secondary Education on the sorting for by the present opposite party OP4 lordship, the block education.
Why do you want to trouble him? The board itself has said it's a genuine certificate.
But subsequently, it has a page 20.
Yes.
This is also issued by the Board of Secondary Education.
Yes. Anyway, they have said that this is a genuine document. Where is the requirement of
this document supplied by the OP4 to us with Annex 3? The document is supplied by them.
And that you have produced.
May take instruction.
Issue emergent.
Though they have filed the representation, I think
no, that will
instruction.
No, we will
finally discharge.
I know that.
No, it is better to take instruction.
That's what. Issue emergent notice. EGA to accept notice for the all parties.
Yes, all.
This is my law.
First, stay of all further proceedings till next date of the hearing.
Lord, may I say on this? All these certificates are issued by the Board of Secondary Education.
Correct.
He has not been added as a party. Yeah. Even though we have been added as a party from 1 to 4. If at all they will come in picture.
No, he himself has said that it's all genuine. Why he should implead him? If he disputes, he would have made him a party.
The second one also issued by the same board authority.
Yes. Let us see. But proceed again. Yes. Yeah.
Item 31.
Here the petitioner is working as a non-teaching post of peon, whereas the order of termination by Annex 3 wherein by the OP number 5, the principal was having no authority to terminate the service of the petitioner along with 5 others without following any procedure, madam. And he also already
when terminated?
on 25/7/2025. Annexure 3, 25/7/2025.
25/7/25.
Madam. And he also already
terminated.
OP number 5, the principal.
Principal. He has no power.
No power, because the governing body under the rule is the authority, and there is no valid governing body. And he will also already interfere in the matter in respect of other 5 petitioner. Annexure 5 is the similar order.
Sir,
Annexure 5.
Emergent notice. Mr. Mohanty to accept AGA to accept notice for the OPs. All OPs.
No, 1 to 4.
1 to 4.
5 to notice.
Notice to OP5. Interim order as in WP number
21053.
21053.
2025.
2025.
Page 21.
First one. Call this matter along with that WP in the 3rd week of September.
That has been posted by to October.
Along with that WP first.
Item 32.
Item 32, my lord, at the outset, I have given that rule. Actually, later on I verified because my learned friend, my associate has given me. That is a part of the from the that is part of the Supreme Court rule. No, it is not. Say what happened in that particular net. I have downloaded the copy. The High Court rules heading is High Court rule. He has got it. The part 8, it is he has got it part 8 review, but it is meant for Supreme Court 1966. That is the confusion.
Ask the HP that
So that is the confusion.
Sir, you have to look to the contents.
Page 20 is the
by mistake. Yesterday he mentioned it was not part of the book.
Yes, that I have stated, sir. It is not in the part of the book.
But the review is
the same thing I am saying.
Supreme Court because by virtue of Article 137,
Page 120.
Supreme Court has got the
say 120, the same volume, my lord, 121. Index 121. 121.
That is Supreme Court.
That is the because in one lot it has got it. He has given me, I have given it to man.
Review 181.
That's the mistake.
See, no help to.
No, openly saying that. Sometimes it happens. What happened?
Because
the clients give that rule, we go by that. Although we should verify before passing the things to the bench. We should verify true. But such things happen.
After seeing this,
therefore, those rules we need not look into it. Those rules we need not look into.
No, because now this is
separate.
No, but I have my further argument. Therefore, I'm just
still further argument.
No, just 2 to 3 lines because I got the mistake. I rectify myself.
Yeah.
So what I beg to submit, madam. We may not take help of the Supreme Court rule because that is not applicable to us.
Not applicable to you.
So now my humble submission is
to keep it a little away. Yes.
No, I will get everything bounded and done. But what I want to only submit, my lord. All these are repetition, but I'm just 2 to 3 lines.
I will not repeat because I have disease of the things.
Yes. My lord have collected. What I want to say, because this thing crept into my mind, so I have extended my argument in that way. What I beg to submit, my lord. 24C is the Act, the Odisha Education Act.
You have said
that. Just my satisfaction because 3 lines, my lord.
I have a disease of recording everything. Whatever I hear, whatever I read. Therefore,
just to conclude to that submission, what I have, because this is a part I am to discard.
Let him say that. You have nothing new to say. Yes.
Now, what is online? What I want to say is, but once the 24C appeal is presented to a court of law, this is the Hon'Ble Court. So now 24C case is over. So now the question is, there is some mistake in that order. That is why I am before this Hon'Ble Court in a review. Maybe a review.
Unless you show the power of review.
Yes, that
is the argument.
That is the only argument.
There may be mistake.
Yes.
There may be mistake.
Yes. How should be remedied?
Existence of mistake per se is not a ground to rectify.
Yes,
Unless that power is given.
Is given to the court. That is the only issue, my lord, before this honorable court. What I beg to submit is, my lord, now this review part or after the appeal is over by an order. Now, my lord, my responsibility in one line, my lord, the High Court has to proceed as per its own rule, and that is why the review is there with the High Court to correct its own order. So that is why our petition is there. That is all about our answer.
Who appears for the
Last opinion also, I have submitted the judgment of the Honorable Supreme Court.
Yes.
That is reported for a copy of given.
Yes.
The party nearest one is Government of NCT, New Delhi.
Give that copy.
Can you give the reference?
This was the case where whether LAO can review the award or not. LAO is not a court. LAO is not a court.
Yes.
No, there was he had resorted to section 13A of the Act, and he went on to reduce the award, which was not permissible because there no power of review was available under the Act.
That's right. Now, what his possible answer would be, if it were to be tribunal, then this judgment is applicable.
Quasi-judicial.
Quasi-judicial bodies. Once it comes to the High Court, whatever rules operate here will be operating even in those matters.
So my respectful submission is that under the High Court rules, Orissa High Court rules, there is no scope for review because that power of review cannot be conferred because it is a procedural thing. Substantive power is not there in the rule. It has to come from the Act itself, that is Orissa Education Act. If the Education Act provides, then and in support of that, you have coordinated bench judgment.
It has held that no review is maintainable.
No review is maintainable. No.
High Court also.
High Court has said.
Read that. Read that paragraph.
But that is for me to that I know that.
We should resist our anxiety. We should be shant of how. Then we start understanding things. If we are in anxiety, fear, love, hatred, affection, then we will not be able to know grasp the truth at all.
Order.
Read that. Show that paragraph, saying that in an appeal arising from the order of the tribunal. I do not know. I am asking you to read. First you read it yourself. Then after being convinced, you can trade that to the court. After all, the bar is a marketplace of ideas. But one argument is available to you. Though I am not convinced of my own proposition, you may be convinced of that. Therefore, you may argue the matter that way.
My solution.
So you are not drawing any milk from that judgment.
I'm only submitting that if the statute doesn't permit.
No, my question is specific. Even first year law student can understand my question. I assume that way. You can't derive benefit from that judgment in support of your proposition. Answer is yes or no. Binary answer. What's your answer? It was before the tribunal.
In the context of,
as your friend said, this
judgment passed by a revisional authority under the revenue law, that is commission or consolidation.
Therefore, it is not applicable to court. Go to other point. What other point you want to say? On fundamentals, we should not be in loggerheads. We should not be with loggerheads, with the foundations of law.
Sir, 24, section 24B.
Yes.
Now, just. And most of the regulations are, I will proceed.
Yeah.
Section 24, B. Adjudication by tribunal.
So this is not by tribunal now.
No, I'm coming here. So the original proceeding starts with the tribunal.
Appeal is continuation. Therefore, what applies to tribunal applies to the this court was also my proposition to him. Anything new you want to say?
Nothing. No.
Don't waste time, the court. If you have genuine propositions, I will treat. Whether your client is here, behind you, no. Sometimes you have to satisfy not only the judge, but client also. Then you will go on arguing, I can understand.
The last 2 days they have argued, I have not put up. This much only, I have taken only 5 minutes of my left time. And
no problem of time. I have abundant time, provided contentions are genuine. Only so far as review petitions are concerned.
There are two types of cases, two major cases, my lord. The review is concerning this.
Which are those?
Other cases?
Review.
These are
Review matters.
3 to 3 cases.
First sub-item.
Whole matter, sir.
Which are they?
Review 234 of 12. First one, ma'am.
234 of 12.
Next is my lord. 264 of 12.
2463.
264 of 12.
264.
Next, my lord.
Next one.
275.
Next one. But there is another review petition. 299 of 2010 is there.
no, so that has been withdrawn.
Withdrawn?
Yes.
But why they are
So they had the on that
reference.
They have filed.
That is for reference.
that has gone now.
That is disposed of.
That is the notice.
Then review number
264, next one 275.
264.
264 of 12.
264 of 12. You are right. Then
275 of 12.
270. 276 or 275?
275, 276 both.
275, 276 both.
My lord.
You are right.
292 of
290.
That is related to the reapplication.
No.
No. That cannot be decided. That is review.
That is separate.
This is not that review, my lord.
275 is not that review.
No. 292. There is a
292 I am not. 275, 276 are review.
yes, same order, my lord.
Against one single order.
Yes.
All these review petitions.
FAO number 177 of
One matter wrongly.
Then review petition 292 is different.
it is arising out of a WPC. Writ petition.
Writ petition.
That is different.
All right. Then these orders I am reserving.
My lord.
Possibly
After my lord, from
tomorrow is no court. No. Monday.
Last
Your Lordship may.
last year is the review.
state.
State has not.
Yeah.
I have prepared a short complete note.
Very good.
Compiling all the and while the respect information that review is not maintainable.
Review is not made.
Yes.
Learned
Note of submission.
with learned advocates appearing for the OPs in the review petition and submits that. review is not maintained. Anything new to be stated?
Yes.
Yes.
Because other day my land senior placed before you.
Also senior only.
Yes, ma'am.
You are also senior only.
No, the designated senior one.
That makes no difference to me. All advocates are same.
Yes.
Yes.
Other day, my land senior has placed the entire the structure of the Education Act and the constitution of the administrative tribunal, then 24B, 24 and rules, everything. But I would like to demonstrate before your lordship that your lordship may kindly come to my note today. How this Odisha Education Act came. Yes. Before the Odisha Education Act 69 came into force, all these conditions of service and management and establishment, everything was being regulated through education code. Then,
kindly hear his argument. Brother, he is arguing, learned the AGA and on his feet. So when you argued, he heard your argument. That's it. You may not agree, but we should hear at least. Yes.
Then the government found difficult because of inconsistency and regulating the employees of the aided education institution. So they thought of bringing this Odisha Education Act.
Special Act.
Yes, Special Act. That I have quoted.
Therefore, you say Special Act overrides General Act.
General. That I have written. I have quoted the aim and object of that act also. Then you will also may kindly come to 24A, Constitution of the Tribunal.
Yeah.
That is there, and they have also placed that subsection 6 of 24A, that is empowering the tribunal to have the same power of enforcement of its order in the manner
execution,
only execution, for limited purpose. You will actually keep it in mind that for limited purpose.
Correct.
So CPC is not applicable. Wherever they have made it applicable,
they have said it.
Yes. Then 24B, you will actually kindly see the tribunal, it is made clear that the tribunal shall not be bound by the procedure laid down in the Code of Civil Procedure, but shall be guided by the principle of natural justice and subject to any rules made by the government, shall have power to regulate its own procedure. Then you will also may kindly next page, section 24C. That was inserted. I have also given that reference.
749.
Yes, said inserted, that is appeal to High Court. After the tribunal, there was no mechanism. So, in the year 1998, it was inserted that the state tribunal's order can be is appellable and can be made appeal before the Honorable High Court. Then you will also make section 27, that is the rule-making power, and in that sub-rule 4 of 27, that is until that other day they were demonstrating, until rules are made under this section, the rules contained in the Odisha Education Code, Odisha Education Code means before the Act came into force, code which were in force immediately prior to the coming into force of this Act shall, in so far as they are not inconsistent with the provisions of this Act or of the Constitution, be deemed to be rules made under this Act. So, in cases where there is no rule, so to that extent the education code guided before the Act came into force, that will govern the field. Then the tribunal, Odisha Education Tribunal rule came, and your lordship may Other day, my land senior was citing before your, demonstrating before your lordship, Rule 26, inherent power.
Correct.
Before that, your lordship has answered 25, power of tribunal of a civil court for the purpose of taking evidence.
Only evidence.
Only evidence. Then 26 is inherent power. What power? The tribunal may exercise inherent powers for the aims of justice as contemplated under section 151, 152, 153 of CPC. So, section 114 CPC or 47, Rule 47, that has not been made. So, when there is no such specific provision, so this review is not made. Then my legal submission to your lordship. So far the provisions of Orissa High Court rules are concerned, the High Court of Orissa has established various set of rules for its own practice, procedure, administration of subordinate courts, limited purpose. That then, to be specific, I have also made procedural rules, administration rules, specific area of rules, etc. The Honorable High Court of Orissa has also rule-making power. So High Court has no dispute that the High Court also has the rule-making power. They have also recently made PIL rules, so also Orissa High Court has made. The question arises whether the High Court, in the absence of specific provisions of power to review either in the statute or in the rule, can review its own judgment or not. That is the question your lordship has to answer. Then, under the provisions of Odisha Education Act, there is no such provision to review either in the Act or in the rule, and further the applicable to CPC is specific purpose and limited. Then a review, a review should not be, that is, I have written, the review in the should as a disguised appeal. Then, ordinary statutory provisions known as the primary legislation are superior to rules. Act is there. Act provides appeal to High Court. Nothing, there is no...
If they intended review, they would have made provision for review. Submission.
Yes. Then, rule must remain consistent with the act under which they are framed. Rule does not provide for review of any order. Then, in the essence, High Court rule can interpret and supplement the statutory law, not contradict or nullify it. Even if they have demonstrated to your lordship that under the provisions of Chapter 8, Rule 23, or that is, High Court has the power to review. So no, High Court cannot nullify the act provisions of the act and it. Then there is no rule by an authority cannot override the provisions of statutory act and rules made by legislation. High Court is an authority. High Court has the power of making the rules. So High Court cannot, the provisions of rule made by the High Court cannot override the effect of the statute made by legislation. That your lordship has to keep in mind. Then there is no specific
last. Learned DG.
Yes, sir.
Please repeat the last proposition.
Yes.
What you say is rule making power of the High Court under Article 225.
Yes.
Or such other articles like the Proviso 2309, etc., is subject to statutory power of the legislation. Once the legislation is brought in,
yes,
the High Court has to obey.
Then I have brought two
positions.
Yes.
In addition to filing a short note of his submission, contains that the power of review is a substantive power and it cannot be inferred by reading the compendium of provisions. And further that, the rules promulgated by the High Court under Article 225 or such other provisions of the Constitution have to be subordinate to and subservient of the legislations made in plenary power of the legislature. First off, there being already the Orissa Education Act in the form of legislation, one need not travel beyond the parameters of the legislation to find out the review power.
Right. I have also proposed decision. To that I'll pass to your lordship.
Pending. What these three decisions say?
One decision your lordship may, other two they have followed. I will place the last one. Vivek Purana aided elementary versus director of elementary education.
Of this High Court? This court?
Yes, no. The High Court is the Madras.
Madras High Court.
Yes. They relied on the Supreme Court's order, your lordship judgment. Your lordship may kindly come to paragraph 10. Still, paragraph 10. To support my submission to your lordship, paragraph 10. A division bench got your lordship.
Paragraph 10 in which judgment?
It's a Vivek Purana.
Indian Philippines. Indian only.
Yes, sir. A division bench, the implementing circulation and so on, sir, the division bench of this court held as early as 1956 in K. Muthuwadi Velu versus Regional Transport Officer Vellore, MA, District and others. Year 1950.
Yes. Which paragraph you are reading, sir?
Paragraph 10, my lord.
Paragraph 10.
10.
The impugned circulars. It
Yes, that. The division bench of this court held as early as 1956 in K. Muthuwadi Velu, also, the Supreme Court that the statutory rule cannot override the provisions of an act. The Supreme Court in the case, the Central Bank of India and so and so, held that the rule must yield to the statute.
Correct.
Following this, various high courts have considered the nature of rules, regulations, bylaws and administrative instructions issued by the authorities. From the principles laid down by various high courts, including Madras High Court, it can be safely stated that in the interrelationship between act, rules and regulations, bylaws, administrative instruction has been laid down by judicial pronouncement, and the cardinal principles of interpretation of statute are as follows.
1, 2, 3, 4. Of them, 3 is relevant.
Yes, that's.
Yes.
That's right.
Thank you.
One provision may kindly take note of that letter patent article 29. That book is there. This book is there. Just I'm reading out from that. Because we got it from
the rule.
That is page 502. The letter patent. We start with page 494.
That doesn't convert to read a pin. The letter printer of 9th.
That page is matching, I think.
502.
No, yes, and it starts with 494. That will be. I will read 502. This book. 29, madam. Civil procedure. What this says, madam. And we do further ordain that it shall be lawful for the High Court of Judicature at Patna from time to time make rules and orders for regulating practice of the court and for the purpose of adopting as far as possible the provisions of the Code of Civil Procedure, being an Act number 5 of 1908 passed by the Governor General in Council in and provisions of the law which has been or may by made amending or altering the same by competent legislative authority for India to all proceeding in its testamentary, instate, and matrimonial jurisdiction respectively. This is from this one, they have amended all these rules. Government of India Act 1915 was there. This letter pattern is of dated.
Government of India Act 1915.
Yes. First it was 1915, thereafter 1935.
1919 it was.
No, 150. First is 1909. My lord, the Government of India Act.
Yes.
Government of India Act, my lord, is my knowledge, limited knowledge, my lord. It is Act of 1911. Sorry, Government of India Act 1911.
1911, 1990,
1935 is the last. 35 is the last.
Sir, Government of India Act 1915.
Yes, 15 is of the amendment.
108. That's the provision.
You are reading from which
the Act itself. From the Government of India Act, Section 108, each High Court may, by its own, provide as it thinks fit for exercise by one or more judges or by division bench constituted by two more judges.
Disclosed.
1915 Act.
Yes, sir. 1915. Government of India Act 1915.
But that act is repealed. By
everything. Yes.
Repeal in 1935.
Yes.
First came, my lord, Indian High Court's Act 1861.
Correct.
Thereafter, my lord, this became Act 1911.
Yes.
Thereafter,
anyway, all these acts
Government
are
of India.
repealed
Yes,
by 1935 Act.
35 and 35 after that Constitution.
Correct.
And that is why the 225 of our Constitution has taken care of if anything prior to this. Because this High Court rule was promulgated in 1948 prior to the Constitution. So this is how this rule came.
Heard reserved judgment.
One point. High Court has no power to but but Supreme Court has the power under Article 137. I am just guessing for your lordship. 130. Judgments are orders by the Supreme Court.
Correct.
Subject to the provisions of any law made by Parliament or rules made under Article 135, the Supreme Court shall have the power to review all orders made by it. So that
itself gives power.
Yes.
Such power is is your content.
High Court is no. That's.
Sir, only one line.
Sir, let AGA draws attention of the court to Section 130,
Article 130.
Article 137 of the Constitution to contend that wherever policy of the state intends review power, such power is expressly given, and similar provision being absent in the Education Act, contention to the contrary should be rejected.
Yes. Can you also look to one High Court rules, that Appendix 8, which is a part of the High Court rules?
Appendix
8, sir. 8. Roman 8.
Page number?
Sir, it is my
your lordship shown it to my lord other day. Page 149.
Yes.
149.
Yes. I have given a note, my lord. I have given the page, everything. The rule we are relying upon.
Appendix 8.
Yes.
Coding sheet in the High Court of Orissa, Chapter 6, Rule 28, review petition arising out of appeal. You also look single and division bench. Single is so far as this appeal is concerned, single, and so far the division bench is writ appeals.
This is only a format.
Yes.
This is a format give power.
Sir, this is statutory. So far rule is concerned, that is a part of the rules. That is what intend to say. Rule 28, yes. That is what. And if my learned friend's argument is accepted, my respectful submission to your lordship is that High Court have no review power, irrespective of appeal or.
No, it all depends upon policy of the state. Under which act matters.
Sir, there is no such statutory provisions debarring filing a review application.
No, not debarring. Providing.
Providing, yes. Yes, sir. Sir.
No cases, there is no power of review.
And,
This CPC 147.
Our
High Court provides against the criminal case also reviews permissible.
And state must have filed over hundreds of cases, review application. And that is a different thing. So far as the FO is concerned, arising of the Education Act. Well, sir, I just maybe reiterate, sir. Let's wait. 11. This is this appendix which I have shown to your Lordship. This provision under the High Court rules, provided your Lordship will accept this. Every application for review made under the ground of the discovery of new and important matter or evidence within the meaning of Order Participant Rule 1 of the Code of Civil Procedure shall be accompanied. That is provided Rule 11. So that rule, that is chapter already shown. Chapter 6. I prepare a short note for your Lordship and I'll give it for your Lordship.
What day you should give it?
By Monday.
Otherwise, tomorrow it will be ready. Order will be ready.
Tomorrow?
I don't keep, yes, I do not keep any orders at all. All orders should be disposed immediately within 1 day.
I think tomorrow is holiday.
2 days. Tomorrow you have holiday.
Yes.
But Monday judgment will be over. I don't keep any.
If your Lordship, I can.
You can leave it with.
Yes, I can give it to me.
Your names you can read.
Mail ID, I can send it to me.
Mail, instead of that, you can give one hard copy.
I can give it
to any of our officers. I get those only those access. Okay.
I mean, pattern on last item is a review filed by the government.
Review filed by the government. Even then, that also should go. That also.
Last matter, that is review number 74 of 2019.
Are you aware of that before taking argument?
What your law should be set.
Of course, you are right.
I'm not whether the state.
He is not a piece of the government. He says what is the law, correct position of Yes.
Item 33.
Yes.
That other matters, there is a nexus. There is the same institution, but the petition and other things are there. FAOs are there.
Those I will post in the second week of September.
Because in that other cases, coordinate bench has directed the state government to cause an inquiry. And they filed a petition to recall that after participating there in the inquiry, in the midst of the inquiry, now they have filed a petition to recall that order. In fact, the recall. They have given it a very chaos in a different manner, but essentially I understood that is a recall of that order.
Let us see. That in the second week of September?
Immediate, my lord.
Second week of September. Yeah.
My lord, highly petition for recalling the expected order dated. Recalling the expected order dated 16/10/2019, my lord. Similar already order, my recall this order.
You have changed everything in that?
No, my lord. Corrected.
Correction you have done?
No.
The correction you have to do?
That's fine.
Give that to him, we will get it corrected. How many days? 900 days delay?
900 days.
Yes. Correct that.
May I please, my lords? The petition is very limited grievance. Petition is an illiterate villager will file the writ application that earlier present opposite party number 5 to my lord 8 private opposite party was the village leader. What happened in this case, my lord? He filed a FIR against this private opposite party, my lord. The opposite party of 5 to 8 my lord directed petitioner to withdraw the FIR, otherwise will face the consequences, my lord. Petitioner did not withdraw the FIR, for which, my lord, village meeting was convened, my lord, and in the village they were decided. The prayer, my lord, read. So, direct in the village meeting decided, my lord, directed not to use village pond and not to use village pond, not to use village temple, and he was debarred to even talk to any village people that he was alone in the.
Where is your prayer?
My prayer, my application, I lord, so you can have a glance.
Page number?
That is prayer, my lord, page number
7.
My lord. 7 million, correct.
Read.
The petitioner therefore prays that the Hon'Ble Court may be graciously pleased to admit the application, and after hearing both sides, the Hon'Ble Court may be pleased to direct the opposite parties, 1, 2 for the government ballot, to take step to bring the petitioner and his family member to the main
stream of the society. Means what?
Mainstream they are directed to leave alone, not use the village fund, not use the temple, not use the talk to anybody but one. When you talk to many village person, one interesting one relative of the petitioner went to meet the petitioner. The village people imposed 11,000 cost. He meet the petitioner. Another case, please.
Is it excommunication? Do you know the word excommunication?
Communication, excommunication.
No, communication is different. Excommunication is keeping people away from the society.
That
has happened here.
My Lord,
Except using that word, you have said everything.
My Lord,
which I will not understand.
That particular word, my Lord, I am unable to say.
It's a legal concept. It's not dictionary word. It's a legal concept.
Lordship. So, and the last talking to Lordship directed that collector to take immediate action against me, Lord.
Why, brother, Mr. Mohanty, who appears for the opponent?
Government, Lord.
What is this excommunication on the basis of caste? All caste walls should fall down.
Item 32.
Castes have created havoc in this country.
This honorable that was directed the collector to take immediate action, otherwise the petitioner will, the family members will, their life and liberty already check, they will kill, otherwise they will finish. And another with their permission, that the daughter-in-law of the petitioner went to his father-in-law house prior to this incident, the village people devouring her not to come to village. That has been compromised. Inspector is not taking any step. Your Lordship may direct the state government to the inspector of the police area to take immediate action to save the people, petitioner and his family.
That will not. No, that will not help. You have to bring those officers before the court. By giving representation, this will not solve. They will say representation is considered and proper action is taken. Then how to verify? So you take notice.
Your Lordship, and for the opposite party number 5, 6, and 8. Lordship, as per the noting, it's an inadvertent mistake on our part, Your Lordship. We have actually today we have submitted the wakalatnama for opposite party number 6 and 8, and we are appearing for 5, 6, and 8, and not 7.
Whether notice was issued earlier.
Notice was
it is a notice matter.
It is after notice. 25/6 to 25 minutes. That order was passed.
25/6/25.
Collector was directed to take immediate step. But IIC whom are playing between the petitioner and village people. Who should take immediate step?
1 second. You have said something all wrong. Yes. Yes, what action you have taken? 25/6/25. Brother Judge has made an order. 70, more than nearly 80 years are over after Constitution came into effect. Still these things are happening. What others will think about our society? Now, what is the action taken by the concerned collector?
Let me call it on Monday. I will take it. On Monday.
A coordinate bench of this court-wide order dated 25/6/2025 had said as under. Reproduce that order. Learned counsel appearing for the petitioner vehemently submits that because of excommunication of the family members of the petitioner, they are facing untold hardship. And then, despite the above order, nothing has been done by the collector. First off. Next one. Learned AGA seeks a short accommodation.
I have received the instruction, pursuant to that.
Instruction 2.
Instruction from the Deputy Superintendent in charge, Golonthara PS.
Why have issued instruction and
No, the file was not. Was just now file came.
seeks a short accommodation to confer with his officials and come back. First off, matter is very serious. First off, therefore, call this matter on
26th Tuesday.
25 Monday.
Yes.
Yes.
Depluralized.
Your Lordship, my submission is that we are not for opposite party 7.
You appear for
Opposite party 5, 6 and 8.
Dr. So appear for OP numbers 5, 6 and 8 and not 7.
Not so.
And not 7. Registry to print the published accordingly. For 7, who appears?
He's not in India right now.
Not in India. From outside, he is managing all these. 7.
Well,
OP 7.
OP7 mallet, that is the 5, 6, 7, 8 the village leader who by the instance this will happen mallet.
No, he is abroad.
No, that is good. Village people abroad not in that.
So he's abroad and so we.
My knowledge is not there mallet. I don't mallet that.
But he will not inform you, show you his passport before leaving the country.
I'll take instructions. I ask my client petitioner whether the item petition opposite party 7 is abroad or in the.
Or you can delete 7 so that officials will take the action.
My lord, that official is the collector and the IIC is the main, my lord.
That's what. Therefore, the private parties you may delete, give up, so that they will take action against the concerned person.
My lord.
Otherwise, notice has to be served on the person who is abroad. That will take another 2 years. You will never get the justice at all.
That is your lordship correct. Only collector and the IIC is the main block who can compromise the matter, settle the matter, everything the IIC.
Notice OP number 7 on the request of net counsel for the petitioner is dispensed with.
Well,
first stop. All right. On Tuesday.
As per the instruction, there is a meeting and a settlement has been made.
That should be placed before the court.
Yes.
Court is the custodian of the people's rights.
In form of instruction, I will file affidavit.
You file that affidavit. Then what action is taken?
So then you will kindly come make it 26th next day. 26. Because all 3 days are holidays.
I would have directed the presence of the collector, but at this stage, I will not do. But the next time, if nothing is done in the matter, something bad will happen in the order. Yes.
Item 36.
The cast walls have created havoc to the history of this country. All our problems are because of this caste and casteism.
Excommunication is a matter of that Catholic period.
Correct.
In fact, subsequently, in our village tradition, that is known as in our state Ekaghargya. That means we will be isolated from the other villages. But now it is not usually happening.
There are 3
at that point of time that was
3 judgments of the apex court. One relating to Bora Muslim community. Bora amongst Muslims. Another is a Parsi. Yet another I don't remember. In these 3 cases, the apex court came very heavily on the communities which had excommunicated the families. It's very bad thing.
79 years after.
What is this? This happening? These happen because of the cats. Cats are always they are China walls. They should be just dismantled like Berlin walls. They should be broken. Yes.
Item 36.
In 36.
Yeah.
It is a matter of 98.
1998. Oldest matter in the court?
Obviously. Before that also second appeals are there.
Older than this. Yes.
But here, the appropriate party is the Barampur Development Authority. However, petitioner's lawyer is also not there. These are all 98 matters. And this is a relation against the Barampur Development Authority under the ODA Act.
Why this is kept pending for all these years?
Sometimes many old matters are not being listed.
More than 30 years old.
98.
No, 20 years old, more than 20 years old.
98.
98. Call this matter.
It may be
none
process
appears.
in the meantime. Also.
None appears for the petitioner.
No, none for the petitioner. Because it is in respect of the unauthorized construction under that authority of the Barampur Development.
What is challenged in this petition?
This is at Annexure 4, my lord. Saying, my lord, it is a notice issued by the Barampur Development Authority in respect of the unauthorized construction of the buildings. On the specified plot, my lord.
What the notice says?
It says, my lord, it is at page 18, my lord, kind of.
You are requested to intimate this alternative so in writing whether you would like to get
after coming into force that ODA.
28 of ODA Act on payment of the compounding fee. After receipt of reply, you will be intimated the amount of compounding fee. If no reply is received from you, as if you are not interested.
So in the meantime,
compounded.
It must have been compounded because the unauthorized construction and construction which is not in proper form by the authority which was approved. So subsequently also in Cuttack Bhubaneswar also there is a scheme under the amnesty scheme. That some of the construction which has been debated the original construction plan, this is being by paying some amount, it is being compounded. So in their earlier provision also in 98 there is a provision for compound. They must have been compounded in the one time. So for that possibly they might not have been interested to pursue this matter.
91. Section 91. Down to 1990. Yes, 91 is compounded.
91.
They have mentioned that.
Exactly.
Under the Orissa
Development Act.
ODA Act. ODA Act. But how to, who you appear for whom?
No, I am for the state, my lord, because I have my duties to assist, my lord.
Correct.
So it is a Department of Housing and Urban. Under this application,
we want to know whether that the compounding has happened in these cases, so that we can dispose of the matters if compounding has happened.
Well, practically it will be difficult because there are different authorities under the Housing and Urban Development. This is at Bhubaneswar Development. They have their specific laws. This is not a coming up. Even though department is Housing and Urban, but it is difficult because it is a 98 matters. It must have been compounded and it is available records is with the Barampur Development Authority.
Who appears for
this is my lord,
Barampur Development Authority?
The panel of lawyers, of course. Or as a last chance
advocates appearing for the petitioners on record are absent in this in these old matters. First up. So give last opportunity for appearance. Call this matter on 26.
Because for the Barampur Development Authority, the law concern name is also available in the list.
Petitioner.
So both were not interested.
The panel advocates are made.
Mr. Name is reflected in the call.
Mr. So and so are absent. First time to give last chance for appearance. Come on, call this matter on 26. First time. Any phone numbers are available of these lawyers?
Phone number is available. Phone number is available.
Very good. Registrar Judicial to talk to learned advocates for the party over phone and tell them to come to the court to argue the matter. Yes.
Item 37.
May I please, Your Lordship?
Yes.
Your Honor, the petitioner was initially engaged as non-formal educator supervisor during the year 1998. Thereafter, she was disengaged due to closure of the non-formal education scheme. And thereafter, another scheme came up, that is Education Guarantee Scheme, EGS scheme. And the petitioner was also not considered as against that scheme, although in that scheme there was a condition that preference will be given to the
those who worked in this scheme.
Yes, that is page 16. I have annexed 3, my lord. Page 16.
Given representation also.
My lord, I have filed representation and again.
By 2014,
yes.
That is rejected.
And I had also approached this Hon'Ble Court in WBC number 8119 of 2014, in which Your Lordship may kindly see page 28.
Saying,
considering the contentions raised by the parties and after perusing the record, it is the admitted fact that earlier the petitioner was engaged under non-formal education scheme introduced by the government of Orissa, and she has discharged her duty under the said scheme. The said scheme has been abolished in the year 2001. Subsequently, EGS scheme was introduced, and as per the guidelines, the case of the petitioner has not been taken into consideration, and the said scheme was also abolished. And the government has decided to rehabilitate those education volunteers as Gana Shiksha under Sarva Shiksha Abhiyan. But the reasons for discrimination of the petitioner have not been indicated anywhere. If the government has formulated such guidelines, and priority is to be given to those who have gained experience, this should be observed under the new scheme. Without doing so, the petitioner has been discriminated. And thereafter, this Hon'Ble Court directed to file a fresh representation, which will be considered. And petitioner has filed the representation on Annexure 9,
that's rejected,
which was rejected on Annexure 10, madam.
Yes, so where was the question of directing for consideration? Court has recorded the finding only. Court should have directed, give engagement to him.
But in the meantime, all these 2-3 schemes, they have been abolished long back. It is of 2002.
When schemes came to, but there is a direction by the court.
And
facts are given.
Subsequently,
that he has worked in that.
Subsequently, Annexure 10 was
on what ground it is issued? Annexure 10.
Annexure 10. All these cases of the petitioner along with others is in serial number 11. That has been duly considered.
Considered and rejected.
And rejected.
Rejected on what ground?
But at page 34, may I read it?
Yes.
That the second parameter, that the petitioners have stated to have been engaged as a non-formal facilitator in different NFU centers, where they joined as such. They have stated that to have been retrenched due to closure of the NFU scheme. They have been engaged as education volunteer under the EGS scheme as per the SN School and Mass Education Department Resolution of 2008. The retrenched education volunteers working under the EGS were rehabilitated as Gana Shikshak under the Sarva Shiksha Abhiyan, that is SSA. Since the petitioner were never working in the education volunteer under
this is also the court has recorded a finding that they have worked.
But prior to EGS, there is a NFU,
They worked.
Then they have worked. And subsequently, after repeal of the same, so far the EGS is concerned, they have not worked. For that purpose, they could not be observed. That is the finding,
But that may not be correct. Their very case is, though we have worked in a particular scheme, that scheme came to an end, but new scheme is launched. In that, others have been absorbed, but we are not. That is their case. That was considered by the coordinate bench.
This is I am conscious that is a old matter. May I be permitted to file a specific instruction to that effect why that person has not been because this is the ground that so far this EGS scheme, they have not worked Thereafter, my lord, after the NEF scheme.
No, but they have not taken them to work at all, is their contention. Because see, the finding of the coordinate bench, they say they have worked actually.
Exactly. 2 successive schemes that has all been abolished.
No
At
schemes
least a
are-
non-formal has been
no schemes now.
No.
But
Scheme has
what
been
you
closed.
give to other people whom you have continued
They have
in,
been absorbed.
they have been absorbed.
Yes.
Where have you
But
stated?
we have been ignored.
The Lordship may kindly see Annexure
Annexure
6.
6, your Lordship may kindly see.
Annexure
Page
6.
22.
That is their letter, government letter.
37/2008.
My lord, after the new scheme came into force, the inspector of schools, the senior administrative officer of the director elementary education, they issued this letter, submission of information on number of remaining unemployed ex-EFA NAP teachers.
Where is the absorption order? It's not an absorption order at all. And actually, how many years you worked actually earlier?
I have worked for 3 years, my lord. 98 to 2001, when the scheme was closed.
But what can be done now?
My lord, now your Lordship may kindly see Annexure 4. This is my lord, this is the letter issued by the Government of Orissa, Department of Education, that's minister's letter. There it is clearly states that 14,000 vacancies were there. They can absorb only 15 or 20 teachers are left. You can consider the case. Now, my lord, we are all age bar. Most of them they have crossed the age of 50. With a hope and aspiration, they have filed this writ application. A day will come when they will get a job. At this time, even if within 11 years, my lord, they have not filed their counter.
No, that's all right. Mr. Mohanty, if thousands of vacancies are available.
14,000. My lord, I am consistent. It is a matter of 2002. In 2001, the said scheme was abolished.
That's right.
Subsequent scheme came into force, my lord. Even thereafter, that scheme also closed. But so far, this contention of this page 34.
Yes.
So, as some of the persons have been left out, not that all persons, many persons have been observed. So, this has been categorically the stand that
If there are so many vacancies and there are trained hands available now, I also read in the newspaper that the minister has taken the decision to go for immediate recruitment.
that is junior teachers, my lord. That
Junior
is the
teachers.
junior teachers.
Well, yeah, anyway, whichever, just have.
I am not standing on the way, my lord. But my consideration is, if at all I will take a specific direction, because there are 15 persons. So far the writ application is concerned by virtue of this.
You have discussion with your officers.
Yes, ma'am.
Come back on 3rd of September. You tell them.
So if at all something will work out,
That's what.
keeping in view their earlier appointment,
Appointments. Because earlier here they were before the court.
they are before this court that is very much available in this.
In almost every case, first or second time they will never win at all. 3-4 times, every time coming, spending time, money in the courts. That's not the object of judiciary.
Let me return back with all exercise and
this
taking it.
matter.
And they have disposed of 15 matters along with my case. How? All matters are not same. All engagement letters are not same.
Mr. Mohanty, Ladda taking note of earlier rounds of litigation, agrees to have conference with his clients and with his officials and come back with some positive response, hopefully. But call this matter on 3rd of September? 10th of September. 10th of September. Yes.
Item 38.
No, please. On that day, don't come with objection statement.
No. I am conscious, man.
Yeah.
The matter regarding disengagement of the petitioner from the post of Shiksha Sahayaka after 5 years from the date of appointment, my lord.
After 5 years.
5 years, my lord. On the ground that the computation of a B.Ed mark, percentage of a B.Ed mark is lower than from my actual number. That is 38.
Your marks are less than what was required.
My lord.
After 5 years.
After 5 years.
They complain that you were not teaching well.
No, madam. They have the wrong committed by the government officials, my lord.
What is this, Mr. A.G.?
My lords, in fact, there was a error in calculating his numbers. Instead of
my lord, on 7/8/2025, your lordship is directed to file some books due to
lesser books are given.
My lords, in fact, that was not available in local market. We have placed order through Amazon. It is on the way.
Some books.
The Amartya Sen is available, na? Idea of Justice. In the market. Theory of Justice by John Rawls is available.
Yes, well.
Except number 2 may not be available.
In the meantime, I have filed a rejoinder. That also got tagged with this file.
Not yet tagged?
No. On 20th, I have filed. So,
if there is a mistake from your side, you have to make it right now.
Well, it's, in consequence, a meritorious person is deprived of the job. That is the problem.
No, but actually, by calculation, who is more meritorious?
My lords, 20 marks wrong, my lords, we have filed counter.
No, that counter we look into only if these 3 books are given, because that is the order.
My lords, that we have filed a letter, my lords.
On applying for that?
Yes. E-commerce site of Amazon India. We have placed orders.
All right. So we'll call this matter on 11th of September.
Well,
by that time, you comply with this. Then we'll look into your WS. Yes. 11th of September. Yes. Next.
Item 39.
39.
Item 39.
None appears for the parties. Calling 3rd week of September as a last chance. Yes.
Item 40.
My lords, here I beg the apology for file is somewhere misplaced.
Misplaced. Call order. 17.
My lord.
Registry to give at least on file of.
Yes, I'm good.
Yes.
I will do. We'll get from the court otherwise.
Registry to furnish pen drive file.
So item 41 has been asked.
41, 42. Yes. 17. Yes.
Item 43.
None appears for the petitioner. Call in 3rd week. Yeah.
Item 44.
Well, item 43, I am sorry, I am 43.
Yes.
I'm sorry, extremely sorry, my lord.
43.
Last occasion, my lord, your lordship directed them, my lord, to file counter because counter was not filed. This is a case, my lord, where suspension without any inquiry, my lord, was imposed and subsequently, my lord, it was revoked. That period, my lord, they have not paid salary. So your lordship last occasion said, why you are not filed counter? Cost.
And next week you can file.
Next week you are doing that?
Yes.
Yeah. He wants 1 week time.
1 week time.
Well.
Yes. Call next week. The request of AG. Yes.
My lord, first week of September. Because
first week of September. Okay.
Wait, please, Lordship. Here the last occasion.
40%.
Yeah.
Wait, please, Lordship. In the last occasion, the state sought for time to obtain instruction. But the caste certificate, I applied for the caste certificate. That was rejected. I filed an appeal. Appeal was also rejected on the basis that I could not produce the ROR. In ROR, my caste is not mentioned as...
in record of rights, how caste will be mentioned? ROR is record of rights.
Yes, Your Lordship.
In respect of land.
Yes, Your Lordship.
How caste will be mentioned in ROR? Appeal is rejected on the ground that ROR
yes, I could not produce, and the original order also that the name of the caste is not mentioned in the ROR. So
this is the, I do not understand.
Highly misplaced.
Misplaced. Give your file to him, one copy.
Extra copy also.
We have extra copy. So you need to furnish one pen drive.
I have the...
You give copy. You look into the second week of September.
Much obliged.
You have to undertake the exercise under Madhuri Patil. 95 Supreme Court. Actually, ROR, etc. Unless you have
SLVCs, they are.
Well, in the 2023 rules of Odisha, it also specifies that the field inquiry is to be done in view of the 1994 Madhuri Patil and certain such procedures are also laid down.
Comedy is there.
Let us see what
things were not done.
Just looking. Yes.
Item 45.
Much obliged.
45.
Please, my lords. My lords, by this writ petition, the petitioner are praying for re-examination of +2 Upasastri examination, my lords.
Re-examination?
Re-examination.
Why?
My lords, on 3 grounds, my lords. Because there has been delay and latches from the administrative authority, the examination conducting authority, my lords.
No, what is your right to re-examination? Under which law that right is given to you?
Yes, there is no rules and regulations for right to re-examination. There is no rules from the side of the university.
Then how can you ask writ? No right, no writ.
No, my lords, because the delay was in issuance of admit cards to us. Therefore, we couldn't appear in the examination itself. My lords, the examination...
How many students?
85 students of the same college. No students appeared, my lords.
Because they did not give the admission card.
No, my lords. No admit cards was given, my lords. My lord,
when they were supposed to give the admit card?
For that they do not have any rules also. Only thing that they have issued, my lords, is a notification
saying, just what do you say, brother? Who appears for the board?
Board,
university. They are conducting the examination.
You are for university.
Yes. One passover, Mr. S.N. Nayak actually.
What passover in 15 minutes? I will have it in the first week of September, 3rd of September.
Well, the problem that these people are facing, my lord, this is the +2 final examination, my lords.
+2 final examination.
And the +3 admissions are currently going on, my lords.
Yes.
They will lose 1 year, my lords. They will lose 1 precious year, my lord.
You appear for the university?
My lord.
Yes. Why did you not issue admit card to these students?
My lord, petitioner was appeared last year, my lord. They have form fill up in the year 2024-25. And admit card issued in his favor. Their examination date was fixed. Program was fixed 4 to 25. 19 to 25. Admit card issued in the center. Petitioner college center you have fixed minor by the university. Admit card issued in the center minor. And 20-25. Instead of collect the admit card, petitioner institution go hither and there for change of center minor. Because he has tried to...
Who appears for the college?
College minor notice has been already given.
Could have issued notice. This honorable wants to know whether the one which they admit card as communication was issued by the college man. Your lordship has directed earlier this honorable court has issued notice. Till yet he did not appear, my lord. And
issue police notice to OP. Which college it is?
OP5, my lord.
OP5.
OP5. Returnable.
Principal
in 1 week.
Yes, sir.
Call this matter.
My lord.
On 2nd of September.
My lord.
My lords, if I may bring your attention to one document. My lords, may kindly come to page 63. My lords, they say that on 19th, the schedule was given for which examination center, which college will be attached. My lords, in that, my college was attached to Karanjia College. My lords, after that, 24th was the date of the examination, my lords. 23rd was a Sunday. 22nd, all the students of the colleges went to the college. They waited till 4 p.m. No admit card was given because the principal didn't have the admit card. And instead, my lords, when they sent
admit card were already distributed.
No, my lords. My lords,
issued to the principal. What is the procedure? They send it to the college.
My lords.
College people have to distribute it to their students.
My lords, they send it to the examination center. They send it to the Karanjia College, my lord.
In this
examination center.
Principal already intimated to the person, student, my lord, to collect admit card on 22nd to 25 and 23rd to 25 at the time 10 a.m. to 5 p.m.
For all 80 students.
For all students, 80 students.
My lords,
despite the notice issued by the college principal, the student did not come to receive.
80 students will not come. 1 or 2 students.
No, my lord. Because their sole intention, their sole intention to change the center, my lord. They are failed to mobilize their for the change of center. Due to change of center, they are unable to. They decided not to collect their admit card.
Anyway, for 80 people,
my lord,
can't you conduct the examination now?
No, my lord, because examination already over, my lord. Now the second annual examination is held on February 2026, my lord. Already we have no principal provision, my lord, re-examination, my lord. Because once a year, the examination will schedule, my lord. Because of this, if your lordship director that there is some problem will arise, my lord, they can appear in next 26 examination, my lord.
February 26.
February 26. We have allowed them.
You are going to allow them to appear. But 1 year will be lost.
Because of their conduct, manner, because of their failureness, though university has no laches, man. Because the student at the college, they want to change examination will hold at their own center, man. And because lack of arrangement, plus internal problem, man, back there is some college, no room, there is sufficient no room. There is sufficient lack of examination center. Committee has decided not to hold examination in that center, man. And they want to tag up with another center, man. For this, they have entire arrangement was held, man. Fortunately, thereafter, the petitioner institution tried to change their center. They are forced to college to university how to hold examination in their own center, man. This is the problem, man. University has no lacuna. Never failed. University always want to try their students how to examine.
My lords, if I may.
I wish your lordship better to let college come here.
Yes, my lord, that is better.
If a college and student conspire together to shift the examination center, what the university should do?
It was not done with that intention, my lords. The only intention was, my lords, the petitioners are rural students. They are unable to travel, my lords. The examination center which has been fixed is 20 kilometers away.
20 kilometers. We wrote examination after running 90 kilometers. How can there be examination center at your doorstep?
My lords,
it cannot be.
With that intention, that prayer was made, my lord. It was not with intention to.
And in February, anyway, they are saying that you will be permitted to write examination. To write it. It is the prerogative of the university as to where the examination should be held.
My lords,
it cannot be held at the whims and fancies of some students.
My lords, we are in this writ petition, my lords, we are not pressing on the location itself.
Yeah.
If the
you appear in February, they will permit you.
My lord,
your fault. Why the university should be blamed?
It is not our fault, my lord.
You proceed against the college for damages.
My lords, may kindly hear 1 minute, my lords. In page 63, there is a letter from the principal to the vice chancellor, in which it's vice chancellor of the client who is London Senior is appearing, in which it says that on as of 22 to 2025. 12 p.m. He has not received the admit cards.
And that's what university. But university is saying we have sent the admit card. Why university will withhold the admit cards when they have sent it to all other colleges?
My lords.
Why to this college they will withhold?
My lords, I do not have an answer.
There is a presumption
also, my
that
lords,
statutory authorities perform their duties in accordance with law.
My lords.
There is such a presumption.
My lords,
and University is not against you. Why it should be against all these 80 people? 1 or 2 persons, if why we see it against registrar, I can understand, I can entertain the petition. For 80 whole lot of the students, the college university will be against.
But the university didn't send us, just didn't send the admit cards to Rinkul directly. It sent.
No, it cannot send it directly. There is a procedure protocol for that. It will send it to the institution. Institution will distribute it. Because identity and so many things will be there, whether you have paid fee or not. Many other aspects are there.
Your Lordship kind of glance the.
Anyway, that now let that college come here.
My
Issue police notice to OP number
5.
OP number 5. Call this matter on 11th of September. You take steps for service. Request to be published immediately. Yes.
Okay. 46.
Whether the center which they wanted was easy for copying, etc.
My lord, all they want to take benefit, all the benefit, my lord. Because due to lack of benefit, take advantage. For this, they have compared to forced to MLA, local MLA, VC, and minister. They forced to try to mobilize to enter their systems. And they want to, at any cost, center should be held in their own institution. Because there is some university felt that last 2 occasions they have allowed to appear their student in their own institution. But they have managed to fail their entire systems. For this university in this year, they have tried to tag up another center.
Have you said in your
have already countered
have you said in your object statement that MLAs, ministers were in?
Already things with yours.
You have stated.
We have filed a counter, detailed file counter, madam.
Have you filed the counter?
We'll file counter, madam. Last occasion, this Honorable Court has fixed the matter 27th October, madam. For this, we have not prepared, madam. By next date, we have filed the counter, madam.
All right. Call this matter
11th September.
11th of September. Yes.
Item 46.
May I please, elements?
Yes.
Limited grievance of the petitioner, my lord. Petitioner is deposited 2,50,000 in the National Savings Scheme in Post Office. That, as per rule, my lord, before 5 years, the rupee encashment is not permissible. But the difficulty of the petitioner, they file a counter, we file the rejoinder, your lordship. The difficulty is the urgent requirement of the money. The lady, petitioner is the lady. His marriage is solemnized on the next 1 month, my lord. His father is suffering from the heart disease, your lordship.
But what can, if the scheme is like that, what should be done?
Any interest deducted by the post office, that may be.
Who appears for opponent?
Already they filed the counter, your lordship.
Counter is filed. They are not here.
No, my
Central government. Central government people.
Union of India.
Union of India is very long. A long distance at Delhi, na?
Government of India.
The government of India. Those lawyers will not come.
I'm there.
Every state, that is the problem.
They are in the vicinity.
I'm there.
Where are you?
I'm there. I'm not well. Therefore, I'm there virtually, suffering from viral. I have filed my counter, Millards. We have filed our counter, Millards.
Come on, well, and come on Monday here to the court.
My lords. I'm grateful, my lords.
Call on Monday. Yeah.
Item 47. Item 47.
Mr. Monty, there is an order dated 8/8/2025 made by me.
That the governing board of the college has to appear, but this post has not been approved.
Within 3 working days, the DG is directed to consider the payment of withheld salary for the months.
Right, madam.
He has worked for the period.
That is not there, but the direct order passed in 2014, madam. Also, can you glance to page 20, madam?
2014.
Madam.
Saying that
the present petitioner has to directed to report in the principal of last para, madam. Sri Santosh Kumar Dhar is the present petitioner, is directed to report to the principal cum secretary and president of the GB governing body, that is madam, of the said college. If at all he wants to join, if he submit his letter of intent to join as clerk The principal in charge is directed to accept it. However, for the entire period of non-performance of duty as clerk, he shall not get any arrear salary. However, he shall get notional annual increment and service continuity. That is there, but after
Last occasion, my lord said direct to the release the salary.
No, there is no direction to consider whether it can be released. They have said that you have not worked for that period at all.
Well, after the direct signature of that period to my lord, direction the release the salary.
Second week of September.
After 2014, before this one, 2025. In between, nothing has been implemented by the college.
In the meantime, petition already retired.
He has retired also. But what can be done? They say that you will not get the arrears of salary in the very order itself. Shall not get any arrear salary. However, he shall get notional annual increment and service continuity.
He was served, where is the notice of superannuation? After 2014,
Series sir, 2025, my lord.
Second week of September.
Well,
Yes.
Always.